gon' talk about it. Let's talk about it. Get in here, we in here tonight. So get in here, we in here to vibe.
Hey, everybody, let me know if you can hear me. Child, it's late, Lord. Oof, Jesus, it's late, y'all. Let me know if you can hear me. Let me know if you can hear my voice, honey. honey, we're gonna be up late tonight, child. Some of y'all are gonna have to catch the replay. I know y'all not gonna be able to hang with me. Y'all, I had to get out of bed for this one. I feel like this is the damn the truth saga all over again because baby, I don't even know where to start. Candy, I know you're gonna be tired, baby. So I know my moderators are gonna be tired. Y'all don't have to stay in here. Y'all can just let them say whatever, and I will time them out if I feel it is getting too much. So don't force yourself to stay up. All right. You can always catch the replay. And this is for anybody that really want to know what is in the defense motion. We have been sitting here patiently waiting to find out what is the defense side, right? What are they looking at? What are they seeing? What are they thinking? We have been patiently waiting to hear something from the defense, right? And baby, it is in. It is in. All right. So we're gonna talk about it. She said, "Wow, hey, more. I will be tired in the morning. I will definitely watch this one." Girl, Miss Katrina, you're gonna be so tired, girl. You might want to go ahead and go to sleep. She said, "Put it on subscribers only mode." I was gonna put it on subscribers only mode, but to be honest with you, I don't mind the questions, honey. I don't mind the questions. Now, I am gonna say this. First of all, let me just go ahead and say everything that I say out of my mouth is allegedly. All right. Hey, Shaysky, baby. Girl, we about to go over this damn motion for the defense, honey. Yes, baby, because listen, it changes a little, you know what I mean? From what we have been hearing here on social media. Y'all, oh, Jesus. But I'm going to need y'all to hold on to your hats, okay? It is going to be a few hours. I ain't even going to lie to you. It's going to be a few hours. This is going to be probably a long live, and I'm probably going to sleep all day tomorrow. But I'm going to need y'all to thumbs up the video. I am going to get a little picky with that because I am about to put out some information. Now, it has already been put out on Team Ramika's side of the house. 9mag TV said, "What's happening? It's buzzing." Yes. Let me tell you something. First of all, welcome to my channel. They told me yesterday you was like this big time blogger. I did not recognize you yesterday. But welcome to my channel. What I will say is the information that I'm about to put out is the motion that was filed by the defense, okay? It was filed by the defense, all right? And listen, it's a whole lot that the public has been denying and have not wanted to admit, all right? So we're definitely going to be going over it. I'm not going to be showing no paperwork because I'm not going to be hit with no violation because it has a lot of personal information in there. And y'all already know how YouTube is. But I have all 4 of the witnesses' names. And I don't mind saying it because this is a public document. So we ain't holding back. We calling witness names and all that. All right. I posted the picture earlier on my Facebook, but I took it down, right? Because she is a child. But baby, y'all wait till we get to witness number 3. That is the state attorney's witness, star witness at that. Baby, all I could do was laugh my ass off. Do you hear me? All I got to say, this case is not all I got to say. Y'all know I have a lot to say, but this case is going to be very interesting. Okay. Very interesting. And we will follow it all the way through. But it's absolutely not a shut and open case. Or should I say an open and shut case, the way the Team Ramika supporters are, or Justice for Ramika, excuse me, are trying to say it is not an open, excuse me, it's not an open and shut case. All right. Before I get into this, I'm gonna go ahead and tell you from me looking at these papers and my own observation, the state has an uphill battle. I mean, a straight up uphill battle. Okay. It is not what people think it's going to be. It is a straight up uphill battle. All right. So with that said, let's get into this. Let's get into this tea. All right. Now, I'm not going to read every single thing because some of this stuff is just preliminary and we know it. I'm going to breeze by some of it. All right. And just the important stuff I think that we're going to talk about. Hey, real girl, I thought you said you was going to sleep, girl. I didn't know that you let me know if you want to come up, but if not, I'm just gonna go ahead and start it. But you told me you was going to sleep, girl. Listen. All right, so let's go. Let's go. Let's go. Okay, from the beginning, y'all. This is crazy work. All right, so let's start from the beginning. First of all, the reason why the motion was put in place, right, was because she said, no, I said I was going to work. Oh, you did say you was going to work. You did say that. Girl, why did I think you meant you was getting some sleep so you can go to work? But yeah, you did say you was going to work. All right, my bad. So welcome in, everyone. Hit that thumbs up button for your girl, please. And let's get into this sauce, this gravy. All right. She said we was just in her live. You was just in whose live? Oh, she said Real T was just live and more. Oh, you was? Girl, I didn't even know you was live. Hold on. All right. I did not know you was live. All right. So let's go ahead and get into it. I said I can't even wait till tomorrow to go over this. I need to go over this now. Hold on. I got my little notes in front of me. So I gotta go by. It's 22 pages long. So I just asked for a summary of all the pages because I'm not about to read word from word. Y'all know that's not about to happen. All right. They have 4 witnesses. So you remember they said they had 15 witnesses. That is absolutely not true. They have 4 witnesses. Okay. Witness number 1 being Carlos Smith. She should drop your email, Amor. Oh, let me drop my email. Talk about it with Amor at gmail.com. Okay. You about to send me something right now? She says they can't even conduct their own live streaming, tuning in over here. Hey, it's okay. Let them tune in because this is information that they probably not going to want anybody to hear. You know what I mean? They probably going to be mad because ain't no telling how they put this information out. Let me just see what she's sending me right quick. Let me know once you sent it. That way I can look for it. She said, I'm about to send you the 911 call. Okay. All right, send me the 911 call. We'll play that. All right, so starting on page 1, did you go over all of this stuff already? Did you start at page 1, Real TV? Well, I'm going to start on page 1. The reason for this motion, y'all, the nature of the motion basically is for this defense files a motion under Illinois pretrial detention law seeking release or reconsideration of detention. We all know that Holly went in, and her real name is Kadasia, but just for this purposes, I'm going to be calling her Holly because that's what we've been calling her all along. But Holly went in on December the 4th, right? Or was that the court date? I think that was the court date, December the 4th. And she was denied release of detention. And it was because of a fist bump that the DA, prosecutor, said it showed a lack of remorse. All right. The judge agreed with the prosecutor saying that, yes, if it showed lack of remorse, then that means that she is a danger to the public. All right. So because of that, they kept her detained on that date. And the judge even said, if you request again, I'm going to deny it. All right. But we all know that the case has now been turned over to trial court. It's no longer in detention court. It's turned over to trial court. So because of that, a motion was put in to have her release in January, which is the next court date, January the 7th. All right. January the 7th. We all know that, right? So because of that, that's what this motion was for. Now, the core position of this introduced pretrial detention is an extraordinary remedy. The state bears the entire burden, and the defendant, Holly, is presumed innocent at this point, right? And the court must apply the statute strictly. That's what the nature of this motion was about. All right. Let's go on to page 2. Governing legal standards. The defense lays out that the statutory framework under 725 ILCS 5110-6-1 says to justify detention, the state must prove all 3 of these events. All 3, not just 1, not just 2, but all 3 events. The state must prove all 3 of these. Proof is evidence. Presumption is great. Defendant poses a real and present threat that cannot be mitigated by conditions. Okay? Now, defense argument says failure on any one prong requires release. So if they can't prove all 3 of those, then detention is an option. They must require release. Okay? And that's what the defense is saying. It is up to the state to prove all 3 of these. Proof is evidence, presumption is great, and defendant pose a real and present threat that cannot be mitigated by conditions. Conditions mean whether she have a curfew, an ankle monitor, and things of that such, right? So they have to prove all 3. Proof is evidence or evident. Proof is evident. Presumption is great. Defendant poses a real and present threat that cannot be mitigated. If they fail even just one, they have to release her, is what the defense is saying. Now, page number 3, burden of proof emphasized. The defense stresses, and they stress this over and over and over throughout the document, okay? Oh, Lauren, I don't care nothing about that, baby. It's public information, honey. This whole document is public information. I don't care nothing about that. That means absolutely nothing to me. If they didn't want us to know who the witnesses were, they would have redacted the document. Their names are in the document. You can Google the name and the mugshot pops up. That's not private information, sweetheart, okay? That's why they have Google out there. No one cares about that. I'm not scared at all, okay? So anyway, now let's continue. I'm sorry. I got to throw it off just a little bit. Page 3, burden of proof emphasized. The defense stresses the burden never shifts. Allegations does not equal evidence. Okay? Detention cannot rest on emotion, speculation, or severity of the charges alone. Okay? Detention cannot rest on that. Emotion, speculation, or severity of the charges alone. Okay? Key legal framing. Courts must evaluate actual events, not narratives. We're going somewhere. We're going somewhere, okay? Page number 4. The state's theory. Now, this is what the state is saying as characterized by defense. This is what the defense is saying, the state is saying. The defense summarized without conceding that the state's theory is trying to say Holly shot the victim, which the defendant shot the victim. The shooting was intentional and the defendant is dangerous. Okay? That is what the defense attorney is saying, that the state theory is saying. Defendant shot the victim, the shooting was intentional, and that defendant is dangerous and must stay detained. All right. This section exists solely to frame what will be challenged next. This is what they're challenging. All right. So page number 5, centrality of witness credibility. The defense explained why credibility analysis is unavoidable. No clear video of the shooting exists, you guys. Let me say this again loud and very clear. No clear video of the shooting exists, which means the shooting is not on video. The shooting is not on video. The state's case rests primarily on witness accounts only. All 4 witnesses gave 4 different testimony. That is what the state is relying on. witness accounts only. They rest primarily on witness accounts only. No video footage shows the shooting. Okay. Therefore, perception, distance, obstruction, and readability matters. This is a threshold argument justifying detained scrutiny. What they're trying to say is perception, what the witness perceived, the distance they were far away from the crime scene, right? The obstructions that there was there, cars going past, them being on a bus and other buildings in the way, and the readability matters. They're saying all of this matters. All of this is the centrality of the witness credibility, right? Again, the state case rests primarily on witness accounts, no video footage of the shooting. All right. Now, pages 6 through 9, let's talk about it. Now, it goes into the primary witness. The primary witness, her last name is Botello, Bottello. She's the primary state's witness. Okay. The defense argued Botello was on a moving CTA bus. She was on a moving CTA bus. Now, this comes from her own statement that she made to the state's attorney. All right. She was on a moving CTA bus. There is video footage that puts her on this bus during majority of the incident, you guys. Majority of the incident, she was on the bus. Video footage proves they saw her on the inside of the bus. Okay. Now it says she was on a moving CTA. She was wearing over-the-ear headphones. So I want you to stop for a moment. These are not AirPods. Okay. These are not earbuds. These are more like Beats, over-the-ear headphones. Okay. The ones that y'all be seeing me in sometime. Over-the-ear headphones. Okay. She was wearing those, y'all. Oh, Lord. Anyway, and it also says, observe the scene only for seconds. She literally looked out the window for 9 seconds. 9 seconds. Looked out the window toward Carlos and Romika and Holly direction for 9 seconds. She claimed she saw Carlos slamming the door in Romika's back. Well, if she did, she didn't make a noise. She didn't make a mutter. She didn't open her mouth and say, oh, what? She did none of that. She did not speak one word while on the CTA bus. She showed no reaction whatsoever. She looked out the window. I can't remember if it said left or right, but she looked out the window. She saw what was going on for 9 seconds, turned her head back around, and did nothing. And did absolutely nothing. She is videotaped on the bus, CTA bus, okay? She was on the bus majority of the time. Now, so she only observed the scene for seconds. She missed the beginning and critical moments of everything. She did not see Romika pull up. She did not see Romika get out. She did not see Romika advance toward Holly. She did not see any of that. Okay? She pulled up after the fact, you guys, after the shooting had already taken place. She was not on the scene at the time of the shooting. Now, I had already put that out. Y'all. Now, y'all can't say y'all just not figuring this out. I had already put that out. But nevertheless, let's continue. It says the bus never stopped at the scene. It never stopped. It continued on and let her off at the bus stop. Okay. It says video showed no reaction consistent with witnessing violence. If you're witnessing a man slamming the door on the back of a woman, you're going to at least, I don't know, hold your mouth open in awe, like, oh my God, like what? You're going to make some type of facial gesture that lets people know that you are witnessing some type of violence. She showed no facial expression, no reaction, which is consistent with witnessing violence. Literally looked out the window for 9 seconds, turned back around, and continued doing as she was doing. Okay, so she lacked the capacity to reliably perceive events. Her testimony cannot support proof, evidence, or presumption. Great. What the hell does that mean? Hold on, let me have them explain this a little bit more. I need more explanation for this. Hold on 1 second. Hold on. I need them to break this down a little bit more because I don't know what that means. All right. So it breaks it down a little bit more. All right. It says, Botello was a passenger on the CTA bus at the time she claimed to have observed the incident. The bus was in motion while passing the area where the incident occurred. The bus did not stop at the scene during the time she claimed to have observed the events. This established that her vantage point was temporarily and moving, not stationary. She was not stationary. What she was wearing and her ability to hear. The motion states that Botello was wearing large over-the-ear headphones that covered up her ears. Body-worn camera footage later showed her removing the headphones in order to hear the officer when they spoke to her. So body cam footage, oh my goodness, they have body cam footage that later showed her removing the headphones in order to hear the officer when they spoke to her, like in front of her freaking face. Okay, she had to remove the headphones at that time in order to hear the officer. But on the CTA bus, she had the headphones on. Okay. All right. It says the defense uses this argument to reduce auditory perception at the time of the incident. Why is this important? The motion does not say that it was noise canceling, but it argues practical hearing limitations, not a technical feature. Okay. So basically it said her with those things on her ear made it impossible for her to hear what she say she heard. All right. Okay. How long did she observe? The motion states that video from the CTA bus shows Botello looking out the window for only a brief period, described as seconds. Only seconds, you guys. After that brief look, she faces forward and continue riding. She did not say, hey, do y'all see that? You see that? You see what's going on? Nope. She looks out the window for only seconds. She turns around, face forward, and continue riding. Okay. She therefore did not observe the full interaction. The defense emphasized she missed the beginning of the encounter and critical moments leading up to the shooting. All right. She said, I love you more, but I pray that they keep that murderer behind bars. I hear you, Fast Track. I hear you, but baby, I don't know. It ain't looking good for the home team. It ain't looking good for y'all. So let's continue. All right. So what the bus video shows about her reaction, what the bus video shows about her reaction, the motion explicitly states that the CTA bus video shows she had no visible shock on her face, no startled reaction, no exclamation such as, oh my God, no phone use, no conversations with other passengers, no mouth movement whatsoever consistent with reacting to violence. Okay. The defense argued that this is inconsistent with someone witnessing a suddenly violent assault. Okay. All right. Now, what she did not see, the motion states that Botella did not observe the beginning of the confrontation, did not see how the encounter escalated, did not witness the shooting itself. Her accounts is therefore partial, not complete. Okay. Distance and obstruction after exiting the bus. Now we are off the bus, you guys. We are off the bus. Okay. Witness number 3 is off the bus. The motion further states that after exiting the bus, Botella was approximately 350 to 400 feet away. Her view was repeatedly obstructed. You want to know why? Well, because cars was moving, baby. They were coming right, left, forward, backwards. It was repeatedly obstructed, okay? She was behind structures and under the elevated train tracks. Wait a minute, what? She was behind structures and under the elevated train tracks, which means that she was standing behind objects under the elevated train tracks. She did not see what she claimed that she saw, okay? It says a portion of the scenes were not even visible to her whatsoever. The defense argues that this distance and obstruction affects visual reliability. Is no way that she definitively saw what she claimed she saw. Okay? So the defense legal conclusion for this, all right? After laying out the above facts, the defendant argues that Botella lacked the capability to reliably perceive the events that she described to the police officer. Her observations are incomplete and unreliable. Therefore, her testimony cannot establish that proof is evidence or that the presumption is great as required under Illinois' pretrial detention law. This is a legal conclusion, not a factual finding. Okay. All right. So according to the defense motion here, the state primary witness, their star witness, as stated in the documents, Botello was on a moving CTA bus wearing over-the-head earphones, observed the scene only for a brief moment, missed the beginning of the encounter, and did not witness the shooting whatsoever. The bus video shows no visible reaction consistent with witnessing sudden violence. Based on those facts alone, the defense argued that she lacked the ability to reliable perceive what occurred, and that her testimony cannot meet the legal standards required for detention. Meaning that Holly Johnson cannot remain locked up based on this witness account. This is the same witness that said there was a fist bump. But I'm going to need you to sit down for this one. I'm going to need you to sit down for this one. I need you to put in the chat, are you sitting down? Let me know if you are sitting all the way down. I need 5 people in the chat to tell me that you are sitting down. Let me know before we move on. Before we move on, are we sitting down? 5 people. Are we sitting down? Are we sitting down? I need 5. Somebody said they laying down. Somebody said, I'm sitting there. Okay, I got 5. There is no video footage. Let me say it again. There is no video footage. Let me say it again. The state has no video footage of a fist bump. It solely came from witness number 3. Let me say that again. The state has no video footage of a fist bump. It strictly came from witness number 3, the star witness. Let me read verbatim, okay? Hold on. Let's read verbatim. Let's read verbatim. It says the motion states that the state alleged Botello observed the defendant and witness Carlos Smith fist bump after the shooting. However, this alleged fist bump is not captured on any POD, which is a police observation device camera footage. The motion notes that Botella did not report observing a fist bump. I don't know that word. That's too many words. Let me see if I know how to pronounce this. I'm not even going to say that word. What the fuck does this mean? Hold on, let me ask what this means. This word got too many damn letters in it. Here, let me put it in here. Y'all tell me what the hell this means. This word got too many letters, and I don't want to jack it up. Y'all know they got more than 5 letters. That word, right? It says the motion notes that Botella did not report observing a fist bump contemporaneously. Contemporaneously, meaning that it was not mentioned at the scene. It was not documented by officers at the time. The motion further states that the body-worn camera footage does not reflect any reaction, commentary, or conduct by Botella consistent with witnessing a fist bump. The defense argued that this allegation appeared later in the state's narrative rather than being supported by real-time events of recording. There is no video footage of a fist bump. It came from witness number 3. Now, I don't know if y'all heard that. Somebody said Google it. Y'all want, okay, let me Google a word. Let me see how you pronounce it. Okay, hold on. Pronounce this word. Give me a sec. Pronounce this word. Hold on, y'all. Y'all got me over here pronouncing these fucking 16-letter words and shit. Hold on. Let's pronounce it.
Contemporaneously.
Contemporaneously. How many letters is this? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17 goddamn letters. Good Lord. Contemporaneously.
Contemporaneously.
Okay, so contemporaneously. Okay. I don't know who that is shooting the birds, but let me just go on and get rid of them. They probably mad because I just told the world that there is no video footage of the fist bump. They mad over here, y'all. Let me go on and get these birds out of here. Hold on. Okay, they gone. Listen, don't get mad at me. Get mad at the camera. Get mad at the state attorney. Okay, don't come over here mad at me now. Come on, chill out. Chill out now. Don't get mad at me all because I am just reading. All right, don't get mad now. But let me say it again for those that's all the way in the bike. Okay. There is no video footage from the state that supports a fist bump. Let's continue, though. Let's continue. So the defense argued that these allegations appear later in the state's narrative rather than being supported by real-time evidence or recording. How the defense uses this legally, and this part really matters. After laying that out, the defense argued that the alleged fist bump is unsupported by video evidence. It is not corroborated by contemporaneously statements, meaning at the scene. It is therefore unreliable as an indicator of intent, consciousness of guilt, and lack of remorse. Which means because it was not on no video footage and it only came from one witness, it will be deemed unreliable. Her word against 2 other people's word, and that is Carlos and Holly. If they say they did not fist bump and this witness say that they did, well, guess what, y'all? The fist bump is out the window. Now, I do have to say this because I had one of my girls and she knows who she is. And I know she in here looking at me, watching me. She said, Amor, I swear I saw a fist bump. Amor, I promise you it was a fist bump, Amor. Amor, I promise you they really did fist bump. Well, the state attorney don't have no video footage of a fist bump. Okay. All right. We got that clear? Okay, y'all can stand up now. Y'all can stand up. Y'all can stand up. But let's continue, honey. Let's continue. Now, so now because the fist bump is not documented or collaborated, it cannot be relied upon to establish that the proof is evidence or the presumption is great for the purpose of pretrial detention, which means they cannot hold her for not having remorse or not feeling guilty because the fist bump is not collaborated. It is not documented. It cannot be relied upon. It came from a witness, and that witness didn't even say it at the time of the scene. She waited, and she said it later. Later, okay, later. All right. So anyway, which means that is the legal use of the fist bump allegation, not to prove innocence, but to undermine reliance on demeanor evidence. All right. The defense motion says that the state claimed that there was a fist bump, but that allegation is not captured on no police cameras whatsoever, was not reported at the scene, and is not collaborated by contemporaneously, whatever, right? Evidence. The defense argued it appeared later in the narrative and cannot be relied on to show intent or guilt. All right. That statement is faithful to the document, not exaggerated, not misleading, and it is court safe. All right. Now, what that does not mean, and this is very important for credibility, right? It does not say the motion proved that no fist bump exists, right? Or it does not prove that the witness lied about the fist bump. What the motion does say is that the allegation is unsupported and unreliable. And that distinction matters legally, okay? Now, I'm just going to tell you, the defense attorney is not saying witness number 3 didn't see a fist bump, okay? She's not saying that. But what she's saying is it's an allegation and it's not supported and it's not reliable. No camera caught a fist bump and no other set of eyes but witness number 3. Witness number 3 is the only one that allegedly saw a fist bump, okay? All right? All right. All right, let's continue. Let's continue. Now, let's go back up to the witness statements. Let me make sure I'm not missing anything. Where was I? No, I started with witness number 3, didn't I? Hold on. Let's go back. Let's go back. So I started with witness number 3 because hers was the worst. Hers was the worst because she actually is the star witness that got a lot of this popping off, and she wasn't even there for majority of the incident. Okay, she only saw seconds of the incident, and the view in which she was at was 350 to 400 feet away from the crime scene. So it is impossible that she heard what she say she heard, or that she saw what she say she saw in details. Okay, now let's continue. Hold on, y'all. So now we are on, let's talk about witness number 4, okay? Oh, wait a minute, hold on. Let's go back to witness number 3. We're not done. We're not done. All right, so, hold on, y'all. I'm so sorry. We got to go back to witness number 3 because she said more than that. Okay, let's go. So I'm going to go back to witness number 3, but let me say this first. So again, the state must prove the burden is entirely on the state. The defendant is presumed innocent. Serious charges alone do not justify detention. Now, this is just for her to be released on January 7th. This is not proving the whole case, y'all. This is just for her to be released on January 7th. The detention must be based on evidence, not fear or speculation. This is where the defense plants the flag. If the state falls short anywhere, then the detention fails, all right? The state theory, and this is the defense summarizing, I think I said that already, that the defense summarized that the state is alleging that that a confrontation occurred, that Holly shot the victim, that the act showed violent intent, and therefore she is a danger to the community, all right? The defense is saying, this is what they claim, now let's test this out, all right? So, am I jumping around? Okay, so it says witness number 3, based on the defense, they're saying that it documented methodology established where she was at the time, what she could see, what she could hear, what the video does and does not show, and what she missed entirely, okay? This is where the bus, the headphones, the distance, the obstruction, the lack of reaction, and the missed minutes are all laid out with citation, okay? Now, it says, I already talked about, it says the motion then moves to after she exited the bus, she was 350 to 400 feet away. She was standing behind buildings under the Greenway Line Bridge, out of the camera view, making a second 911 call while obstructed. The argument here is simply, even if she was trying and trying hard at that, she could not reliably perceive what she claimed that she saw. It is absolutely impossible for her to have seen that, all right? Now it goes on to witness number 4, the crossing guard. I have his name, but we ain't gonna put him out right now. Now, the motion addresses the crossing guard. Now, this is interesting because if I'm not mistaken, I want to say a crossing guard got on a Key's panel. Maybe not a crossing guard. I think that was a school guard. But anyway, so it says the crossing guard said he did not witness the shooting. He admitted his conclusion was based on assumption only. His belief came from interference, not observation. The defense labeled this property as hearsay, inference. Well, it's not interference, it's inference, and not proof. I don't even know why they even took his testimony, but let's see what exactly did he say. Hold on. I don't even know why this was even admitted, but let's just go with it. All right. It says, according to the defense motion, witness number 4 did not see the shooting. He did not observe Mrs. Johnson fire a weapon at all. He stated that he heard Mrs. Johnson say that she had a conceal and carry. Based on hearing that statement, he concluded that she was the shooter. His conclusion was not based on observation, but on inference. He explained his conclusion by stating in substance that he put 2 and 2 together. That is the entirety of what the motion attributes to. So witness number 4 basically said he just put 2 and 2 together, and that's how he realized that Holly was the shooter, because he overheard her saying, I have a conceal and carry, and he put 2 and 2 together. I don't even know why his statement matters, but let's continue. It says why this matters legally and why the defense highlights it. Okay, the defense highlight his statement because legally, his statement is classified as not an eyewitness testimony, not direct evidence, inference / assumptions, hearsay-based reasoning. The defense uses his own admission that he assumed to argue his statement cannot establish proof of how the shooting occurred, okay? So basically, she's saying he's only going by hearsay, that he really didn't see anything. He heard her say, I have a concealed and carry, and he put 2 and 2 together. Now, this is the state witness number 4, okay? Okay, all right. Now, with that being said, witness number 4 did not see the shooting. He said he assumed, at his own words, he said he assumed who the shooter was after hearing a statement about having a conceal and carry. His conclusion was based on inference, not observation. Okay. Witness number 4 did not see what happened. He guessed based on what he heard afterwards. Okay. Both statements are accurate, defensible, and faithful to the motion. All right. So again, I'm not even sure why that matters, but let's go back up. That's witness number 4. I'm taking you through there. Hold on. Let's go to, I'm gonna save witness number 1 for last. Let's go to the DoorDash driver. All right. Hold on. All right, let's see what she said about witness number 2, the DoorDash driver. I mean, the DoorDash delivery guy, same thing. All right, so last name Woods. Now, what he said he observed, he said, I was driving eastbound on Cermak Road. While driving, he briefly observed 2 women engaging in a verbal argument and 1 man standing between the 2 women. He did not stop his vehicle to observe further. All right. Now, what did he not say? Okay. What he specifically said he did not see. Oh, wait a minute. What did he say he did not see? He did not see any weapons on anyone, any physical fight, or any shooting. Okay. He did not see who fired a gun. All right. What happened next? He left the area to pick up a DoorDash order. He entered Momentum Coffee. I guess it's a Momentum Coffee shop. While inside the coffee shop, he heard gunshots. All right. Why does this matter legally? Well, he was not an eyewitness to the shooting. Nobody was. His statement does not establish who fired a weapon, whether force was justified, how the incident escalated. His testimony only confirms that there was a verbal argument, okay, and a man standing in between them. And then he drove off, went into a coffee shop and heard the shots, okay? All right. So witness number 2 only saw 2 women arguing with a man standing in between them, did not see any weapon, did not see any physical violence. He left the scene, did not stop at all, and was inside a coffee shop when he heard the gunfire go off. Now listen, why am I saying all of this? These are the 4 witnesses of the state. Okay? The 4 witnesses of this, well, these are 4 witnesses, and 3 of them are for the state. And I just gave you I gave you the motion that the defense attorney is combating these 3 witnesses. All right. Now, let's go to Carlos's statement. All right. Let's go there. All right. Hold on. She said the witnesses are weak, girl. Like hot piss. Now, let's go into witness number 1, and that is Carlos Smith, which is he was personally involved and the father of the child that was in the car 6 months at the time. What did he state? Well, he said he was present at the scene during the confrontation. He said that there was a verbal argument between Holly and the victim. He stated that the victim ran up on Holly. He stated that the victim swung at Holly. He stated that he was positioned between the 2 women at some point during the confrontation. That is the core of his statement as reflected in the motion. Again, let's go there. Again, he said he was present during the confrontation. Now, this is summary. This is not word for word, okay? He was present during the confrontation. He said there was a verbal argument between the 2, the victim and Holly. He stated that the victim ran up on Holly and swung at Holly's face. He said that he was positioned between the 2 women at some point during the confrontation. All right. Okay. Now, why does his statement matters? Now, let me just say this before we go back. There is no video footage that corroborates what he says. There is no video footage that showed that they were arguing. There is no video footage that showed Ramika running up. There is no video footage that shows Holly firing her weapon. There is no video footage of that. But there is video footage of Ramika doing a U-turn, all right, and driving toward the direction and stopping in the location where they were, Holly and Carlos. All right. There is video footage, and let me just make sure I'm saying this right. Let me make sure I'm saying this right. Because what I don't want to do is state incorrect information. All right. It says there's video footage of Ramika drove past the location where Mrs. Johnson and Carlos were. Ramika then, wait a minute. She drove past it? Hold on. Now, hold on. Now, it's not. Hold on, y'all. Hold on. Yes, it says according to the motion, Ramika was driving in the area. She drove past the location where they were. Oh, okay. So it said Ramika drove past the location where Mrs. Johnson and Carlos Smith were. Ramika then made a U-turn and returned to the area. After making the U-turn, Ramika parked nearby and exited the vehicle. The defense present this sequence as part of the lead up to the confrontation. This is the extent of the factual claim regarding the U-turn. Now, hold on, y'all. I did not know she drove by at first. It says, hold on. Give me a second. It says there's video footage capture a vehicle driving past the location where Mrs. Johnson and Carlos Smith were. The video then captured that same vehicle making a U-turn. After the U-turn, that vehicle returned to the area and later parked nearby. The video is used to show sequence of movement, passing, turning around, and returning. OMG! We did not know that. We didn't know that she passed them and bust a U-turn. Oh, now that is new information that I did not even know, y'all. Who knew that? Raise your hand if you knew that. I did not know that. Oh, say it ain't so. Wait a minute. Who knew that? I did not know that. Okay. Oh, she said she knew. I did not know. You didn't tell me. So she passed by the area first. Then she bust a U-turn and returned to the area. She says no more. They said she made a U-turn more than once. Hold on. When you say they, who is they? You know, I don't go by they. Okay, it says according to the motion, it says that she it only refers to one U-turn, a single U-turn, and then returning to the area. It says she drove past the location once, then made a U-turn, and then returned to the area. So I don't have that in the motion that she made multiple U-turns. I don't have that. I just have that she drove by them and then made a U-turn and came back. She said yes to come back because it's a one-way. So she bust a U-turn and came back. I did not know that, you guys. I absolutely did not know that. Y'all know if I would have known that, I would have said something. I did not know that. Now, now I wonder, are they giving out this information exactly the way it is on the other side? I mean, I really don't wonder, but I'm just saying, you know, I just wonder, will they actually be truthful when they say things, right? But anyway, so the video camera footage caught her driving by and said this, the video captured a vehicle driving past the location where Mrs. Johnson and Carlos Smith were. That video then captured that same vehicle making a U-turn. And after the U-turn, the vehicle returned to the area and later parked nearby. Hold on one second, you guys. I'm sorry, I have to keep my throat lubed. Y'all know. Anyway, so that's crazy. She drove by the area, and then she drove past or whatever. Then she did a U-turn and she came back. Now I'm gonna tell you something that's going to weigh heavily. But let's get back to Carlos' statement right quick. Hold on. Let's go back to witness number 1. All right. So Carlos said he was present. That the victim ran up on Holly, that she swung and hit her in the face. And it actually said, let's talk about that for a minute, because people were trying to say or doubt whether or not she was actually hit. Okay. I think it says something about physical contact was made. Let me just go back to it. Okay, it says the motion state that witness number 1, Carlos, claimed the victim ran up on Mrs. Johnson, that the victim swung at Miss Johnson, and that physical contact was made. I guess she made physical contact with Holly. Okay, so physical contact was made. All right. Now, all right, let's go back. So, and that is the statement in which statement number 1, Carlos. Was that all of it? Let me just go back to his statement. Let me see, was that all of it? Was that, I got number 4, number 3, number 2. Now, is that all of his statement? All right, it says, so now in his statement, I have to be fair across the board. It does not prove that there is video evidence of an alleged swinging. There is no video evidence of her running up or any physical contact made. There is no video. There is no body cam or third-party footage confirming that a punch took place, punch, slap, whatever it was. And no other witness definitively confirmed seeing the victim strike Holly. All right. Now, why does this statement matter legally? Why does Carlos' statement matters? Well, he is considered an interested witness because he is personally involved with the shooter. He has a direct relationship with her and a child by her. So court treats such testimony with heightened scrutiny unless collaborated. His statement is disputed and uncollaborated at this stage, meaning that there is no proof that what he said is true. It doesn't mean that he's lying, but there is nobody to back up his story. What does that say? All four witnesses says something completely different. Not one witness collaborates another one. Not one witness say that they saw everything exactly. Not one. Not one witness saw the same thing. Not one witness even saw the shooting. Not one witness even saw an attack. Not one witness saw Romika get out of the car. Not one witness saw that. One witness saw an argument. Another one claims she saw slamming the door on the back. And another witness said, well, I put two and two together and realized that she was the shooter. And then you got another witness that was door dashing, and he seen two people arguing and Carlos standing in between them. Not one witness say that they saw the exact same things. 4 different witnesses. Okay. All right. So let's go back up. I think I was on page number 6. Let's go back. All right. Okay. All right. No, I'm not on page number 6. All right. So fist bump. So I already told y'all about the fist bump. The motion says that there is no video footage of the fist bump. So and she didn't mention it at the scene or whatever. She thought of that shit later. All right. So now the defense did a risk assessment of Holly and said only after dismantling the evidence does the motion address risk factor. It says Holly has no violent criminal history, that she has a minor non-violent past offenses, like I want to say retail theft, no pending cases other than what's going on right now. She has community ties. She has family responsibility, employment history. Basically, this section just speaks directly to the third legal requirement, danger to the community. So basically it's saying she's not a danger. She has no violent criminal history. She has minor little charges of stealing something out of a damn retail store, right? No pending cases other than this. She has community ties, said that she was a good mother, okay, and has employment history, and it appears that she was going to be going to dental school or something like that, all right? So now, why conditions can address any concerns? The defense argued that even if the courts has concerns, conditions of release exist, monitoring exists, restrictions exist. So there are conditions. Therefore, detention is not the least restrictive option, meaning that she could be confined at home under conditions, okay? That is what the defense is arguing. Detention is not the least restrictive options. There's other options that she can be released up under with conditions, all right? Now, the motion closes by tying everything back to law. It says the state has not met its burden. The evidence is circumstantial. Credibility is compromised, meaning your witness are a piece of shit, right? Proof is not evident. Presumption is not great. And detention is absolutely not justified. Therefore, they request relief and release Holly Johnson under appropriate conditions. All right. So the motion isn't about whether something tragic happened, because they know it did, but it's about whether the state can prove enough under the law to keep someone jailed before trial. And the defense says that they didn't prove that. That they did not prove that, okay? The defense says, you haven't done enough to prove that she needs to be locked up prior to trial, all right? Now, it says that the reason why they are even bringing this motion is because the burden of proof is emphasized. The defense stresses the burden of proof never shifts, but allegation doesn't equal the evidence, and that they've received, after doing discovery, additional information that combats what they originally put out. Y'all, I'm floored. I'm floored. I am floored. No video of an alleged door slam. No video of Carlos putting her in a headlock. No video of a fist bump. No video of her banging on the car saying, come on, bitch, let's fight, let's fight, let's fight. But there is video that proves the person that made those statements wasn't even around the area at the time in which she said she saw what she saw. There is video footage that proves that she was 350 to 400 feet away with obstructed views, cars going back and forth, her ass ducking behind buildings and shit in the greenway. She is on camera, on video, not at the scene for a great bit of the time. She only looked out the window while passing on the CTA bus, which did not stop. Which did not stop. Let me say that again. Which did not stop. She was on the bus and she briefly looked out the window with headphones over her ears on the bus. She's on the bus with headphones over her ears. So you guys, oh my goodness, I don't, this right here is, I mean, it's crazy, but at the same time, it's how in the world the state was able to do what the state did. Where are all the people that claim, oh, I saw the video, I saw the fist bump? They're just very quiet in the comments. They're very quiet in the comments. Where is the video of the fist bump? Where is it? No video of the fist bump. And no video of the shooting. And no witness saw it. No witness saw the shooting. No camera picked it up. None of this. This is sad. Let me see, do I have anything else that's relevant? Give me a second. Let's go back up. And the burden of proof, and this is, even though this is detention, but the state must prove a whole lot. The state must prove that Holly intended to unalive Romeka. Okay? That, matter of fact, let me put it. Right here, it says the state cannot prove intent to kill. This is what the defense says. The burden of proof is on the state. The document repeatedly emphasized that the state must prove its case by clear and convincing evidence. And that's a high legal standard, especially at early stages like detention or bond hearing. So in short, the defense is saying that the state has not met their burden of proof. The state cannot prove intent to kill. The filing state that the prosecution cannot prove, the filing states that the prosecutor cannot prove that Holly intended to kill Romeka or intended to cause great bodily harm without lawful justification. And this is critical because intent is required for murder-related charges. Self-defense is the core argument. The document lays out the legal elements of self-defense under Illinois law and argues that Holly Johnson meets them. To establish self-defense, the defense must argue or argues there is evidence that unlawful force was threatened. The danger was imminent. Mrs. Johnson was not the aggressor. She genuinely believed force was necessary. The level of force used was reasonable. Her belief was reasonable under the circumstance. It specifically note that she acted in self-defense of herself and her 6-month-old son. This matters a lot legally, okay? Now, the state cannot disapprove self-defense. Under Illinois law, once self-defense is raised, the state must disprove it. And this filing is saying the state simply cannot disapprove self-defense with clear and convincing evidence. The defense attorney is saying, state attorney, you cannot, with clear and convincing evidence, prove or disapprove self-defense, you can't do it. You cannot prove that the force was unlawful. You cannot prove that she was not in imminent danger. You cannot prove that Holly was the aggressor. You cannot prove that she was not in reasonable fear of her safety or of her life. You cannot prove that force was not necessary, that she genuinely believed that force was not necessary. And you cannot prove that it was not reasonable. Okay? So the filing is arguing that. The filing is saying, okay, the case law that they use, it says that they used the case law, or she used the case law, and it's documented reference Illinois appellate case law. For an example, People versus Hawkins, to support that argument that a person does not have to wait to be injured, that the aggressor does not have to be armed, and reasonableness is judged based on the moment, that moment, not hindsight. Okay? So what this document is really saying, this filing is arguing that Holly Johnson should not be detained or treated as someone who intentionally committed murder because the evidence supports self-defense, lawful self-defense, and the state cannot meet its burden of proof to prove otherwise. She's saying the state can't do it. She's saying the state cannot prove otherwise. They cannot say that this is not a self-defense case. Now, I don't know about the People versus Hawkins, but I will look that up to see what's on it or whatever, so I can compare it and whatnot. But the defense is saying you can't do it. Even if you tried your damnness, you cannot prove that this is not a self-defense case, that she was not in reasonable fear of her safety. You cannot prove that. Now, again, they're saying based on the information that she currently has. Now, I don't know if this is all that she has or she's going to be receiving some more. So let me just put that out there. All right, because I don't know. But it says once self-defense is raised, the burden shifts. Now, this is not saying that it proves that she acted in self-defense beyond a reasonable doubt. That's not what it's saying. But it's saying the state must disprove it. The state must disprove it. The burden of proof is on the state. And they must prove it by clear and convincing evidence, which means if any reasonable doubt, just a little bit, just a smidget of reasonable doubt, then they cannot charge her with murder. They cannot charge her with murder. So we're going to go a little bit further into this, all right? Why does all of this matter? Hold on, before I say that. Also, the motion says you don't have to be armed to be the aggressor. This counters a huge social media myth. It says, the violence references case law stating someone can pose a deadly threat without a weapon. The size, aggression, and the proximity and intensity all matters. And you do not have to wait to be injured first in order to protect yourself. You don't have to be bleeding to defend yourself, okay? Why does this matter? Now, the document isn't about winning over the internet. It's simply about whether the state can legally keep Holly detained. This ain't trying to change no Team Romika's mind, okay? Or Justice for Romika. This is not trying to win over the internet, win over the media. It's simply about whether the state can legally hold Holly in detention. This motion supports release conditions, lack of detention, weakness in the state's theory, future challenges at grand jury or at a trial. This is just the groundwork for everything that comes next. Okay? So people can keep their opinions. They can stay in their emotions, but the law is very clear. And this motion lays it out. What people feel doesn't override what the state can prove. Doesn't matter if you think she deserved a rot in prison or rot in jail. Can the state prove that she's a threat based on what we know? And what we know is the state is heavily relying on witness account. There is no video footage that shows nothing more than Romika busting that U-turn after passing by them and busting a U-turn and coming back in a direction. So for all those that stated she didn't pull up, well, the video says she did. The video footage says, yes, she did. And not only did she pull up, she drove by first and then bust a U-turn. So for all those that say she was just dropping off her child at school, well, you're wrong. You're absolutely wrong. She drove by, bust a U-turn, and came back. And then she parked. It's on video. It's on video. So the fist bump and all the evidence that people were like, oh, ain't no way they gonna charge her with first degree without no evidence. There is no evidence outside of, I think, her own admission of pulling the weapon, pulling the gun. The state is relying on witnesses' accounts. The fist bump, witnesses' accounts. The antagonizing at the scene, witnesses' accounts. The slamming the door on the back, witnesses' accounts. Witnesses' accounts. So anyway, so detention seems very likely on January the 7th. I think that Holly lawyer did a great job in challenging the state, and I absolutely believe that they will win this round. Okay, they will win this round. It just makes sense, especially after finding out that there is no fist bump video, because that just floored me. And then to find out that she drove by and then bust a U-turn and came back, baby, that's intentions. That's I'm on demon time right there. That was absolutely, I'm on demon time. Okay. Okay. Now, what else I want to read? Hold on, y'all, because it's more. But I talked about the case law. It says, let's talk about this for a second. It says, case law supports the motion, cites recent appellate cases saying courts can and should reconsider detention, especially when new information come to light. The early decisions relied on limited facts. And this tells the judge that you are legally allowed to reverse yourself. Okay. Meaning that at the time that she went to court, she did not have the information in which she has now. And the fist bump was used to show no remorse. And there is no video footage of the fist bump whatsoever. Okay. So because of that, then it becomes, unreliable information. And I'm sure the judge did not know that at detention. I'm sure he didn't know because, you know, the state attorney actually threw in there and said something about their CTA camera, but he didn't say what the CTA camera captured. Let's go over that for a minute. Hold on. I'm going to go over what the CTA camera captured. Let's go over everything that the CTA bus camera captured. Okay, let's go over that right quick. So what does the camera show? All right, it shows that witness number 3 was on the bus. It shows that she was seated on the bus, that she's on the left-hand side of the bus, that she's wearing large headphones covering her ears on the bus, and that she facing forward initially, okay? Now it shows brief visual attention. Botella briefly turns her head toward the window. She looks out the window for approximately 9 seconds. I need y'all to count 9 for me. I need somebody to put in here 1, 2, 3, 4. No, 1. How you count seconds? 1, 100, 2, 100. No, 1, 1,000, 2, 1,000, 3, 1,000, 4, 1, all the way to 9. Let me know when you get to 9 seconds, because that's how long she looked out the window, for 9 seconds. Okay. She looks out the window. It says she turns her head toward the window and she looks out the window for 9 seconds. And then she turns her head back forward and continue riding. There were no visible emotional reactions. Her mouth does not move. She does not appear to gasp, yell, or exclaim. She does not display shock or alarm. She does not even alert other passengers as to what she saw, which directly contradicts her claim that she audibly reacted. She said she was like, oh my God, like whatever, right? She said she heard Ramika say, I just dropped my fucking kid off. She had headphones over her ears, y'all. Headphones over her ears. And she looked out the window for 9 whole seconds. So anyway, back to what they caught. So they caught that. And then it says the bus does not stop. The CTA bus continues moving. It does not stop at the scene whatsoever. It proceeds eastbound. And Botella remains seated as the bus passed. She ain't even getting off the bus at the time, y'all. She is on the bus. Now, timing limitations. The footage confirms Botello did not observe the beginning of the encounter. The video footage confirms that. She did not observe the beginning of the encounter. The defense states that she missed. Now, I need y'all to sit down for this one. The defense states that witness number 3 missed approximately 9 minutes of the interaction. 9 minutes. She looked out the window for 9 seconds. And she missed approximately 9 minutes of the interaction, meaning that she went nowhere around for 9 whole minutes. But she comes on a panel. She said, that's a whole lot of time. It is a whole lot of time. But she comes on the panel and she puts together a story for these people. She put together a flattering story that got these people panties in a wad. This lady she needs to be on somebody's stage. This lady said, she ran around the car and she banged on the window and said, come out, bitch. Bitch, come out, bitch. Bitch, come out, bitch. Fuck you up, bitch. She didn't see none of that, y'all. None of that. She did not see none of that. This is an unfortunate situation. But for someone that's 19 years old to come out here and put together a fabricated story that could potentially have someone locked up for a very, very long time. She put together a theatric story. She needs to be on someone's stage. But see, let me tell you what she didn't realize. She didn't realize that the defense team was going to do their homework. She didn't realize that they was going to pull not just what the outside of the bus shows, but what the inside of the bus showed. The inside of the bus zoomed in on her. Her whole actions was seen on camera. Baby, I told y'all that this witness was full of shit. And this confirms it. Everybody around here, panties all in the motherfucking wad. But the witness said, but the witness said, but the witness said, the witness ain't seen shit. But 9 seconds. Turn her head like she ain't seen a damn thing. She wasn't outraged then. She became outraged afterwards. But the notorious fist bump. I'm shocked and appalled. I'm shocked and appalled at the fact that there is no video footage of the fist bump. And ain't nobody out there saw a fist bump except for witness number 3, the state star witness. Well, the star witness is a liar. The star witness got busted in her lies. The star witness was all over the place. The star witness did not see what she said she saw. The star witness did not hear what she said she heard. I told you that a good defense attorney was going to dog walk her ass. And we ain't even at trial yet. We ain't even at trial yet, y'all. We ain't even at trial yet. This is interesting. Where are the 15 witnesses that came forward for justice for Ramika? Where they at? Where they at? Where are they? The star witness. Based on this motion paperwork, the star witness is already a non-credible witness. She's already non-credible. Non-credible. If they show in court the video, the CTA cameras showing that she was sitting on the bus, it did not stop. I was even giving her that. I was like, oh, if it stopped at the light, but it didn't even stop at the light. It passed right by the scene, you guys. Make that make sense. The bus didn't even stop. It continued going. She gets off the bus. She crossed the street. She's behind buildings and everything. She missed 9 entire minutes, or it says approximately 9 minutes. 9 minutes of the incident. But claimed, I saw everything. I was there. I saw it with my own eyes. She even said she saw Ramika after she got shot and she looked into Ramika's eyes. Raise your hand if you remember her saying that. She said she looked into Ramika's eyes. That is what this girl said, that she looked into Ramika's eyes. How could she see Ramika's eyes? When she wasn't even there when Ramika got shot. She wasn't there, you guys. The star witness was not there, you guys. So the CTA footage is going to be used by the defense to show that there was limited vantage point, limited duration of observation, inability to hear, and inability to observe initiation or escalation. Okay? They actually got her on this bus. I'm blown away. I'm blown away. So the camera footage that they do have, even though it did not observe the shooting itself or the notorious fist bump, it did pick up Romika passing by, and then coming back and whipping that car around. The same vehicle that pulled up, the white vehicle, it drove by them first. And then it came back around. It busted Yui and it came back. She intentionally pulled up on Holly and Carlos. It says that Holly was transferring the baby from the SUV to her vehicle. Let's talk about that for a minute. Hold on one second. Let's talk about what Holly was doing when Romika, because she said something very important, like, oh, I caught y'all. Let's see what she said. I finally caught y'all, or something like that. All right, it says, the defense motion says Holly was in the process of transferring her infant child. She was outside of her Chevy Cruze. She had just removed her 6-month-old son from Carlos's vehicle. She was placing and securing the child in the back seat of her own car. This was happening at the moment Romika's white Kia made a U-turn and returned to the area. All right. Now, let's see what she said. All right, hold on. So it says, hold on. The defense says, hold on. Hold on. Did she say, I finally caught you guys? Hold on. Let me see exactly what she said. Hold on one second. I think it's, I finally caught you guys together or something like that. Hold on, I'm trying to see where is that. It's something about I finally caught you guys together. I'm looking for it. But anyway, it says they started a verbal exchange. I want to say I saw it earlier where it says when she got out, she said something like, I finally caught you guys together or something like that. But it said that Holly pleaded with her. Holly pleaded with her to leave me alone. Leave me alone. It says that Holly pleaded with her to leave me alone. Pleaded with Romika. Leave me alone. Not, oh, bitch, you want to fight? You want to fight, bitch? Bitch, you want to fight, bitch? Bitch, you want to fight? Let's fight then, bitch. Let's fight. No. It said that she pleaded with Romika to please leave me alone. Okay? She's Miss Kent says, I don't think Romika circled twice. It seems she was driving east and made a U-turn. Well, the video footage, Mrs. Kent said that she passed by them and drove down, made a U-turn, and came back. So that's what the video shows. I haven't seen the video, so I don't know. But that's what the video shows, baby. That ain't what the that's not what the defense attorney just pulled out of her hat. She actually says the same vehicle passed by them once, drove down, did a U-turn, and came back. All right. So that's not my words, that's theirs. Okay. That's what apparently the attorney saw on the camera, which is going to be shown in court, I'm sure. She said she was driving east on the street and made a U-turn to drive west. Well, it says that she passed by them. I don't know. You might be from there. You may know better than I do. But it says that she passed by them, drove down, made a U-turn, and came back to them. So whether she saw them or she not, she said, you said she didn't make 2 U-turns. No, it doesn't state 2. It just says that she passed by them. And then it says she passed by them and then made a U-turn and came back. But you know, here's the thing. Everybody thought she was dropping her baby off at school though. Right? But anyway, it says Carlos, it says witness number 1 says that Holly asked Romika to please leave me alone, pleaded with her. It didn't say ask, it says pleaded with her to leave her alone. To leave her alone. Just imagine, please leave me alone. Just leave me alone. Leave me alone, right? But that ain't what type of time Romika was on. She said, I was responding to the chat. Okay, all right. Thank you, babe. All right. So I did not know that. I did not know that there was no video footage of the fist bump because I was relying on people that started the, started this case early. You know, I got on it late. And people were telling me, oh, More, you got on it late. You didn't see the fist bump, but this really was a fist bump. And then they scrubbed the internet and got the video with the fist bump off the internet. Hell, I was believing they asses. I was literally believing there was a video of a fist bump because why? I don't know, because I didn't start with them right. And they were like, oh no, there is a fist bump or More. I saw it. I had like at least 15 people in my chat screaming up and down that they saw the fist bump. They saw it. Oh no, it's on recording. It's on recording. There is a fist bump. Well, then why y'all ain't sent it over to the state attorney? Why the state attorney don't have the fist bump? Huh? Why the state attorney did not pass that over in discovery to the defense attorney? Why don't nobody know about the fist bump but witness number 3? She said when something hits the internet, it's always out there. And my dumb ass fell for it. Oh yeah, they scrubbed the internet. I was like, damn, they got that out. Why didn't they get the damn witness testimony when she went on that panel off, right? I was thinking that. But she said a whole fist bump took place. This girl exaggerated a story out her behind. She really did. There's going to be a lot of people outraged at this young lady for coming up with this fabricated ass story. Oh, I didn't even tell y'all this. Hold on. Let me see exactly how she said it. I don't even know if y'all know this. Now, this is funny. Hold on. Well, okay. I don't want to put this out if it's not true. I don't know if she got off the bus with a baby or did her boyfriend bring the baby, but she was seen standing outside with the baby and the stroller, but it does not say in this motion whether she had a baby with her the entire time or did the boyfriend when he came on the scene, because he wasn't there initially. When he came on the scenes after the fact, did he pull up with the baby or did she have the baby the entire time? So I don't know that, and I don't want to speculate on that one. So I'm just gonna pass by that one because I thought I heard that she had her baby with her, but the motion does not mention her baby. Okay. Only people in the chat mentioned that she had her baby with her. Okay. She said, I believe Carlos when he first started talking and on the news, he said what the state saying happened did not happen. He was there. This explains everything. Rebel. This is crazy, isn't it? And you know, Carlos actually said, wasn't nobody on the scene. Nobody was out there when Romika pulled up. Nobody was out there. He was like, that Hispanic girl was not there. She was not there. Even when the pow pow happened, she wasn't there. But everybody kept saying, oh, they over there saying that the witness is a liar. Why would she lie? She don't know those people. Well, why would she do a lot of stuff? Why would she make up a whole entire story? Why would she say she heard something while sitting on the bus with headphones over her ears? Why would she make up any of that? Why would she say she looked into Romika's eyes? Why would she say any of that? Why would she say she heard 5 shots? Why would she say my baby daddy was like, how can you shoot your first love? That was supposed to be your first love. How would her boyfriend even know that? Why would she make up any of this bullshit? She wanted attention. She wanted to fit in some kind of way. Oh, she fit in all right. Because she fooled a lot of people on the internet with her story. She has to know all of this gonna come out. She is caught on video on the bus, passing by the crime scene. She didn't look alarmed. He was slamming the door in her back. Oh, it must be something that she see every day. Because she wasn't alarmed. She didn't flinch. She had no reaction to seeing something violent. None of that. Shame on her. Shame on her. Her story is not collaborating. But the state attorney filed first-degree murder charges based on witness number 3. Because witness number 2 and 4 didn't really say anything. 4 says, hey, shit, I put 2 and 2 together. I figure out who the shooter was by putting 2 and 2 together. Witness number 2 said, I saw them arguing. I saw Carlos standing between them two. But you know, everybody was like, oh no. Carlos called her over here. They lured her over here. They set her up. Oh, really? Oh, really? Huh? Really? They were basing their entire case on witness number 3. Witness number 3. Oh, and they fist bumped and said, it's self-defense, right? It's self-defense, right? This is crazy. Absolutely crazy. You got a woman sitting in prison, not prison, but jail right now, based on witness number 3 lies. Her lies. Now, I'm going to put this out, and I know I don't have to say it, but I am going to say it. I don't think anybody is happy that Romika is unalived, no longer here. I don't think there's anybody out there that's happy about that. But from what we are hearing in this motion that has went before, well, is filed in the courts and will be dealt with on January the 7th. The new evidence that we have, knowing that there is no video footage that corroborate anything that the state is saying, and that she rolled by and came back after doing a U-turn and came back, right? That tells me that she was looking for trouble on that day. Now, how much trouble? I don't know. But she was absolutely looking for trouble. She gets out the car stating, "Oh, I finally caught y'all together. I got y'all now. I got y'all. I finally caught y'all together," or whatever she said. Matter of fact, let me get the exact words. Let me get the exact words that she said. Let me see what she said. Hold on. I know it's on one of these damn documents. Okay, shit, I ain't mean to do that. Hold on, I want to see the exact words she said. I want to say she said, "I finally caught y'all together," but I want to see that. Now, I'm going to tell you something. I know that Justice for Ramika does not like this. They probably was mad as hell, screaming and shit at these paperwork, and they probably think that it's not going to, mean anything. You know what I'm saying? Hold on. Now, this doesn't mean that she's going to be found not guilty or anything. Let me just put that out before we get too excited, right? But in my opinion, reasonable doubt is already there, and we ain't even went to trial yet. Reasonable doubt is already there. Hold on, I want to get the exact words she used. Hold on, let me see, what page is it on? Man, these witnesses for the state. Hold on, I'm gonna get it, y'all. The defense attorney say they will not meet the burden of proof to keep her detained, baby. And I'm sure Team Ramika don't like this, but they'll be all right. They thought they knew everything. They thought they had it in the bag. I told them to wait. I told them to wait. Didn't I tell them to wait? Hold on. I'm trying to see. All right, here it goes. It says, at 9 a.m., 9 minutes after the Kia is seen making the U-turn on Cermak, the video footage from the bus captured. Oh, no. Okay, let's talk about the lady. All right, never mind. Let me go back to the other one. Okay, so they got her at 9 a.m. on the bus. Hold on. It says she's seen on the bus with headphones on her ear. God dang, girl. Ooh, child. I want her to explain that one. I knew her testimony was weak when I heard it. I told y'all it was. Hold on, I'm trying to get to the part where it says when it speaks of her pulling up. Okay, this one. Oh, it even shows it shows exhibit. It says see exhibit number 2, Shark's external street camera. Oh, it gave the camera. So they're gonna show footage on the 7th. It says inconsistent. It says her statements are inconsistent in statement and observation. It was approximately 8:51 a.m. on September the 8th when a white Kia sedan was seen making a U-turn on Cermak, now facing westbound. But it showed at that exact same time, she was on a 21 bus headed toward the Green Line, and it shows proof of that. She claimed to detectives that while she was seated on the bus, that she was nearing the intersection of State. Hold on. Of State and Cermak. She looked to her left. She looked to the left of her outside the bus window, saw two females and males arguing, and the male was seen by her slamming the door on the female with red hair. She told the detective that allegedly upon seeing the incident of Smith slamming the victim with the car door, she exclaimed, "Oh my God," as she was talking to her boyfriend. It says false. Such events of her exclamations are not captured on the camera. So they trying to say she wasn't on the phone. Oh shit. She wasn't even on the phone talking to her boyfriend at all. It says her exclamations are not captured on video footage from the 21 bus that she was traveling on. Exhibit Exit 7 bus footage. It says at 9 a.m., the minutes after the kid is seen making a U-turn on Cermak, the video footage from the bus capture her seated on the left side of the bus with a something in front of her. I don't know if this is a baby carriage. Hold on. With what in front of her? Is that a baby carriage in front of her? She is seen wearing headphones covering her ears as Botella is seen briefly looking out the left-hand side window at the scene for 9 seconds. Botella turns her head forward, facing the front of the bus and continue riding. Anyway, the attorney Ari just caught her in a damn lie is what she did. She just caught this lady in a lie. In a bold-faced ass lie. That's why she's like, I don't want to get on the stand or anything. I gave y'all a statement. I hope it helps you out, but I don't want to get on the stand because I don't want them to catch me in no lies on the stand. But I hope that helps you out. I told y'all enough. Go deal with it. Go deal with that. I told y'all enough. Okay. I guess that's what she's saying. I told y'all enough. All right, it says, witness one, Carlos stated to the police 2 hours after the incident that the victim ran up on Holly, well, Mrs. Johnson, and swung at her face, making physical contact with Miss Johnson. Exhibit 3, witness one, Carlos Smith speaking to the officer on the scene at, okay, it says sorry. Anyway, the danger of harm was absolutely great and intimate. Mrs. Johnson did not know what the victim was capable of or if the victim would follow through on the threats to KI her. With her 6-month-old child in the backseat of her vehicle, Ms. Johnson was reasonably proactive and defended herself and her child. Again, given the history between herself and the victim, along with the victim making physical contact with Mrs. Johnson, Ms. Johnson reasonably believed that the use of force was necessary to avert the danger that the victim was posing to her and her child. It says, notably, yes, September the 8th was the first in-person encounter between Mrs. Johnson and the victim. However, irrespective of it being the first in-person meeting between Johnson and the victim, the encounter absolutely was enough to cause Mrs. Johnson to be fearful of what the victim could do to her, especially given the victim history of violence, threats against Miss Johnson. And then it says, again, at that time, Miss Johnson had an order of protection against the victim. The victim had previously threatened to KILL Mrs. Johnson, had sent numerous threatening and harassing messages to Ms. Johnson and her family members. And the victim on that date, hold on. Give me a second. Oh shit. I already read that. Hold on. So I don't see what it say after that. I guess it cut off. But anyway, y'all, this is going to be interesting. This is going to be interesting. I'm still trying to get to let me go to I supposed to be reading witness number 1 and I got into something else. All right, Carlos said I was trying to see what she said when she got out of the damn car. Anyway. I'm sure Justice for Ramika people are not happy right now. I'm sure they are absolutely not happy. Oh, wait a minute. It says right here, it says, the victim had previously threatened to kill Ms. Johnson, had sent numerous threatening and harassing messages to Ms. Johnson and family members, and the victim on that date of the incident was now advancing toward Ms. Johnson upon seeing her on Cermak with the man they shared children in common. This was absolutely enough to devastate the victim and make her distraught over the fact that there's another woman in the picture. So the defense is saying that Ramika got mad and she was distraught that another woman was in the picture. And that's why she pulled up and acted the way she acted. All right. It said that she swung in her face, made physical contact with her. And she said that basically the danger of harm was absolutely great and intimate. Mrs. Johnson did not know what she was capable of doing. And with her 6-month-old child in the backseat of the vehicle, baby, she was protecting herself and her child, honey. Basically, that's what this says. She was protecting herself and her child. I need to be an attorney, because didn't I say all this already? Didn't I say all this already? She said, what about the 911 call? Let's get to the 911 call, y'all. Let's get to the 911 call, baby. Let's get to the 911 call. All right, hold on. Let's see. I don't see it. Did you send it to me? I don't see it. Hold on. Hold on, y'all. She said she sent it to my email, but I don't see it in my email. Let me check my messenger and see if it's in there. Child. Nope, it's not in here either. Nope, it's not in here. No, I don't see it. She didn't send it to me yet. So anyway, when I get it, let me just hit refresh one more time. Refresh. Nope, I don't have it. So I don't have the 911 call. She did not send it to me. She said it's a transcript. She said, I don't see it though. I don't see, let me check. No, I don't see it. Let me check my other email. But she wouldn't have this. I think she may have sent it to the wrong person. Yeah, I don't see it, y'all. She didn't send it to me. Let me check my, hold on. I just text her. All right, anyway, this is crazy. She said, no, I believe with the detective, prosecutor, and investigators proved it was a homicide. I'm not worried about all the other people. Well, King David, baby, if they proved that it was a homicide, tell me with what evidence? What evidence did they prove that? Because they have none. I didn't get it. Sorry to bust your bubble, but we'll see though. I mean, hey, who knows? Who knows? But right now it's not looking good because you got to understand they have the state, the burden of proof is on the state. The state have to prove beyond a reasonable doubt. And I'm just going to be honest with you. There's all types of reasonable doubt right now. There's all types of reasonable doubt, you know? She said this case does not have one good witness for the state. Not one. Nope, they do not. You are absolutely right about that, Lovely Jim. She said Holly is happy. Holly is happy. I mean, I don't know, but I mean, I don't know. Hey, we ain't trying to jinx her, but I do believe that she will be home in January. Okay. Hold on. Let me just send her my thing again. All right, I just sent it again to her. She said, but isn't that what you Black women do? All of you crash out all the time in so many videos of Black women crashing out just like you're crashing out. Oh, it sounds like you upset, Black man. Oh, David, are you mad? David, don't be mad. What you mad for? Why are you mad? Didn't y'all have y'all time? Y'all had y'all time with y'all narrative, putting out all these lies, believing all these theories, believing all these conspiracy theories. Y'all had y'all time. So, and I told y'all there was only one side of the story out there. Y'all was believing a Hispanic woman that literally got all of y'all in y'all feelings. Y'all was believing her. I told you already. I told you already that that witness was not credible. I listened to her. I broke her statement down. I knew that girl wasn't credible. People tried to come at me for that. Oh, you don't know what you're talking about. Now you're trying to say she didn't see what she said she saw. Exactly. She didn't see what she said she saw. Absolutely, she did not. So don't get mad because now the other side of the story is coming out. Don't get mad, David. No, no, no. Because now it's time to play ball. Now it's time to put both sides of the story out there. But I still want to see that video of that fist bump. I want to see that fist bump that y'all was so excited about. Y'all was so dead set on that fist bump. So excited about it. Where is it? What happened to it? I thought it was the judge had to see the evidence. The judge had to see the evidence. Ain't no way the judge is gonna file, the prosecutor gonna be able to file a first-degree charge if there is no evidence. You guys are dumb. Y'all are crazy. It has to be evidence. There's no way. They seen it. They seen the evidence. They seen her antagonizing Ramika. Yeah, they seen her antagonizing Ramika. It had to be evidence. Where is the evidence? Can somebody please let me know what are the evidence? Nevertheless, now I'm not gonna sit here and say that the case is done like they are. Oh, she gonna rot in jail forever. I'm not gonna say that. I'm not gonna say that the case is over. But what I am going to say is the defense has entered the room, baby. There is two sides. Actually, it's more than two. But we're going to say there's two sides to a story. Really more than two. But only one side of the story has been told thus far. Until today. Until today. Now people can stop with the Holly pulled up at the school on Ramika. Because Ramika drove past them and came back around after busting a Yui to come back to them. Yeah. Why is that? She wanted to say hi. She wanted to see the baby. She wanted to hold the baby. She wanted to rock the baby. She wanted to give the baby a kiss. Is that why she bust a U-turn? Is that why she bust a U-turn? And that's right, Kathleen. Kathleen said, and that's on camera. And that's on camera. For the people that came on my panel and said, she didn't pull up on them. They jumped down in front of the car and flagged her down. And the car had wings and it was like a drone and the remote control brung her over there. Or some shit, right? They were trying, I got it, thank you. They were trying to make up every excuse in the world so they wouldn't say that Ramika pulled up on Holly and Carlos while they were minding their business. Oh, they didn't want to say that. Oh, no, they did not want to say that at all. Oh, I'm sure this hurts their feelings real bad. Oh, I'm sure their feelings are hurt. I'm sure their feelings are hurt. Girl, what did you just send me? What type of transcript is this? All right, it says this is a 911 OEMC event log documenting multiple emergency calls, police detachments, dispatches, officers' actions, and follow-up events tying to a shooting incident near South State Street, East-West Cermak on September 8th, beginning around 9:02 a.m. All right. So it says initial call 9:02 to 9:04. Events open as person with a gun, person with a gun. Caller listed as Miss Citizen. Location State Street. No name victim at this point. All right. Escalation to shooting. Within minutes, events is cross-referenced multiple times. Dispatch notes see the male in white car shot and leg. Oh, I think they mean when they say male, I guess they mean the person. See the male in white car shot in the leg, female shot in face, knife recovered, weapon recovered. Event type escalates to person shot, shots fired. This shows conflicting early information, which is normally in 911 calls. Multiple 911 callers, conflicting description. Different caller report, female shot from a road rage. Male in white shirt, black pants, fired 3 to 4 shots. Shooter wearing red and black. Person shooting off black jeans, a black sweater and jeans. Female shot in the face. Not sure if EMS needed. Caller dropped. Call back. No contact. This matters because descriptions do not match. Shooter description change. Caller's reliable varies. Police and EMS response. CFD fire EMS dispatch. Victim conditions escalate. GSW gunshot wound face critical. Victim condition critical. Scene management. Crime scene tape. Evidence recovery. Weapons secured. Wash down requests later. Large police presence remain for hours. School impact and family conflict. Later in the day, reports involving National Teacher Academy. Calls state, family, and students involved threatening staff, arguing at the school. Oh, wait a minute. Family of student involved. Oh, wait a minute. The families of the student involved threatening the staff and arguing at the school. Who was that? Who was threatening the staff and arguing at the school? I don't know who that was. New events created. ASL tip, assault in process. Oh, okay. These are the secondary events, not the shooting itself. Critical observation, very important. What is confirmed by this document? A shooting occurred. At least one victim was critically injured. Multiple callers gave conflicting accounts. Police responded rapidly and heavily. Weapons are recovered. Scene control. Lastly, most of the day. What is not confirmed here? Who the shooter was, who started the confrontation, exact scene of events, motive, whether claim like road rage are accurate, final victim outcome, arrest details. It says this log proves one thing clearly: public narrative formed early were biased on chaotic and inconsistent 911 calls, not verified facts. That's critical when blaming what we know what happened. Social media assigned blame immediately, and people weaponize early outrage. It says this 911 call log shows confusion, contradictions, and incomplete information, which means anyone claiming certainty early on was speculating, not reporting. All right, now this is just a summary of it, but hold on, let me see. Let me see if I can get the meat out of this. So Romika family called up to the school and was threatening the staff. Damn. So each caller gave conflicting information. They said it was the female shooter, and then they said it was a male shooter, and then they said the male got shot in the leg. So they gave conflicting information. It was all over the place. It says family members fighting. I guess that means at the school. This is a crazy police log. I've never seen anything like this. One of them said female light complexion, green tracksuit has a gun, fighting with female dark complexion occupants of white car across from the school. So actually it says they were fighting. I wonder who made that call. It doesn't say who. Let me see. Nope, it doesn't say. But it's a wireless caller. Then this one says, one male and two females fighting outside in the street. White car and black car. Unknown details. NFI, I don't know what that means. Following remarks copied from DUP. Then it says, child mother was shot. Then there was another caller from T-Mobile. Following remarks, it says, person shot. Okay. Multiple calls of someone being shot. Female shot from a road rage per caller. Oh, wow. Female, white shirt, black pants, has a gun, just fired 3 to 4 shots at the other female, not sure if EMS needed. Following remarks. Yeah, this is kind of crazy. I ain't never seen anything like this. And here goes somebody called in and said, there is a person shooting off, black sweater and some jeans. Man, they put her in all type of outfits. You see, but do you see how people can get things confused? She said, you see what was saying, it was a lot of police codes. You mean a lot of police calls? It was a lot of police calls. And do you see how many, and let me see how many times they said it. She changed outfits. She had on red, she had on jeans, she had on black, she had on jeans. She had on a lot of shit. Hold on, let's see. Let's see how many times they said she changed clothes. Let me give me a second. How many outfits did they? Let's see how many outfits they put the shooter in. It says they put her in 4 different outfits. Okay. One caller say, female, white shirt, black pants, has a gun, just fired 3 to 4 shots. Another caller said red and black clothing. Shooter is a male described as wearing red and black. Another caller said black sweater and jeans. Call reported person shooting off have on black sweater and jeans. And then the 4th one said black sweater, green pants. Some caller later added officer still on the scene, black sweater, green pants. So they put the shooter in 4 different outfits. How many outfits did they put the victim in? It's crazy. But do you see how people can just think they see something and they don't? This is crazy. This is people just speculating, thinking that they saw something that they didn't. All right, it says for the victim. Okay, it said they didn't put her in any outfits. They didn't describe any outfits. However, they did describe the victim as a male in white car shot in the leg, female shot in the face, gunshot wound to the face and is critical, victim condition critical, person has been shot, EMS rolling, 131 victim, 100D witness to area. So they didn't describe the clothing, but they described the victim as different people. They described the victim by the injuries, the vehicle, or medical condition. Let's see who they say was fighting. Who did they say was fighting? All right, so call group 1, road rage fighting frame. Caller stated female shot from a road rage. The next one, 2 people were fighting. It said 2 people, 2 females. A female shot, and it just says it mentioned that both females were black. And then the next one, female, white shirt, black pants, has a gun, just fired 3 to 4 shots. Shooter, male, wearing red and black pants. Okay, I just read that one. Group 4, after the fact. Caller says she was on FaceTime with someone who told her it was a fight. Caller did not witness anything. This was hearsay. Okay. So it said caller type, a road rage call, a female shot call, a shooter description call, and a FaceTime call. It says this is a critical takeaway. Not a single 911 caller gives a clear firsthand account of 2 identified people actively fighting. What we see instead, assumptions, hearsay, focus on the shooter, not mutual combat, no consistent fight narrative. So anyway, they were all over the place. She said they have their numbers. Yeah, but it seemed like they blotted out the numbers on this. I don't know if you did this or they did, but it looked like they took out the numbers. So, but they were all over the place. And those were the people that called in 911. Nobody had accurate what Holly was wearing, what Carlos was wearing, or what Ramika was wearing. They all over the place. Absolutely all over the place. But do you see how easy that's done? Because when you see something like that or whatever, or you witness something like that, you know, I could see that that, you know, you could be all over the place. You're shocked, you know? She said, Vera, you missed the meat and potatoes on the defense motion. More read that earlier. Baby, y'all need to go back and listen, honey. But anyway, let me just try to give you a short overview. So the defense attorney is basically saying that the state is relying heavily on witness accounts. They have no video footage of the fist bump. They have no video footage of the shooting. They have no video footage of the fights. They have no video footage of, I said the fist bump, right? However, they do have video footage of Romika passing by them once and then busting a U-turn and coming back to them for the second time, okay? So she passed them, busted a U-turn, and came back. Oh, yeah. Also, I need to talk about this because it speaks about the restraining order. Hold on one second. Let's go back right quick because it spoke about the restraining order. I'm sure they don't want to hear this either. It spoke about the restraining order. All right, it says an order of protection was issued. The motion states that Holly obtained a court-issued order of protection against Romika. This is used to show documented fear and prior conflict. Okay. The order was entered by default. Romika was given notice and an opportunity to return to court. The judge allowed Romika to seek counsel. Romika did not return to court. Because of that failure to appear, the court entered the order by default. A default order is still a valid court order. It is not informal or meaningless. Okay? It says, a judge previously found Holly concerns serious enough to grant protection. There was an established history of threats and fear. Holly feared on that day of the incident did not come out of nowhere. All right. It didn't just appear that day. It didn't come out of nowhere. She had history of threats and fear. It says, okay, hold on. The defense motion states that an order of protection was entered by default and Romika failed to return to court. And that the final order, hold on, the defense uses this context for fear. So anyway, it says that she knew about it and that it had been served. It actually says that it was served. So I don't know if she means in the court, meaning that she knew, because it does say it was served and she knew. So a lot of things that we heard from even Tia on that first day or whatever, it seems like the attorney is coming back and saying otherwise. So for right now, anyway, it sounds like the restraining order was absolutely active and in effect. But y'all remember when I said, just hold on, wait till we hear the other side of the story? Wait till we hear the other side of the story. People was going wild and crazy and just, yeah, but Tia said this and this person said that. I said, there's another side of the story that has not been told. Now, at this point, may the best storyteller win, but I'm all here for it. I'm here for it because I'm here to see a person that has been harassed and stalked and bullied by a young lady. I am here to see that she gets a fair case, a fair trial. I'm really hoping that she gets a fair trial. You know, no one should have to live their life in fear. No one should have to run, escape every time they getting threatened by somebody and they see their stalker and they have to take off running. No one should have to see that. No one should have to endure that. So I really hope that Holly comes home on the 7th. We won't know until the 7th, but it does look good. I will say that. It absolutely looks good because, to be honest with you, The state evidence is weak. It's very much weak. And at this point, if self-defense disproven it beyond a reasonable doubt, the state cannot do it as of today. Now, unless they got something else up their sleeves that they did not hand over to the defense, I don't even know if you can do that. I don't even know if you can do that. Let me ask, can you withhold evidence? Hold on. Can the state attorney from the defense and present it at a later date? All right, I said, can they hold evidence from the defense and present it at a later date? All right, it says no. The state is not allowed to secretly withhold evidence and ambush the defense later. There are narrow exceptions and timing rules that are easily to misunderstand. Here's the clean, accurate breakdown. The general rule, very important. Prosecutors must disclose evidence to the defense. They cannot intentionally hide evidence and then surprise the defense at trial. This includes evidence that they plan to use, evidence that helps the defense, evidence that weakens the state case. Failing to disclose required evidence is a serious constitutional violation. The biggest rule, Brady's obligation. Under Brady's versus Maryland, the state must disclose evidence that is exculpatory, helps the defendant, evidence that impeaches the witness, evidence that could affect guilty or punishment. And this duty exists even if the defense doesn't ask for it. If the state hides Brady material, convictions can be overturned, prosecutors can be sanctioned, and cases can collapse. All right, so how long do they have? All right, it says late discovery does not equal hidden discovery. Oh, okay, hold on. It says, so why do people think the evidence come out later? Because of timing and discovery phases, no secret withholdings. Here are the legit reasons evidence may appear later. The evidence didn't exist yet. New video is recovered. A new witness comes forward. Forensic testing finished later. Phones are unlocked later. This is allowed as long as it's disclosed promptly once obtained. Ongoing investigation. Prosecutors are allowed to continue investigating after the arrest, add evidence as it develops, but they must turn it over as soon as available. They cannot sit on it strategically. Late discovery doesn't equal hidden discovery. Sometimes evidence is disclosed late because of volume of data, bureaucracy delay, lab backlogs, and police not forwarding material promptly. Still, once the defense receive it, the courts may grant continuance, exclude the evidence, sanction the state if delay was presidential. What happened if the state tries to hold the evidence? If it can show prejudice, the judge can suppress the evidence, exclude it from the trial, grant a mistrial, dismiss the charges, or sanction the prosecutor. Okay, so when evidence. No, I'm not going to ask that. I'm going to say evidence. The state plan to present. All right, let's see. All right, it says yes. In almost all situations, the defense should already have the evidence the state plans to rely on for January 7th hearing. General rule, Illinois criminal procedures. If the state plans to use evidence at a hearing on January 7th, the evidence must already be disclosed to the defense before the hearing. This includes witness statements the state intends to rely on, video or audio footage, police report, forensics, or lab results. Any exhibits the state will reference in arguments. Court do not allow surprise evidence at the hearing. Hearings are not ambushes. Defense has a right to review the evidence, challenge credibility, prepare legal arguments, and decide whether to call witnesses or request continuance. A judge expects both sides to know what evidence is coming forward. Evidence obtained after the last discovery exchange, which could be a video was just recovered, a lab report just came back, a witness was just identified. Even then, it must be disclosed immediately upon receipt. The state plans to rely on an already disclosed material. On January 7 hearing are based on the same disclosure already exchanged, summaries of evidence already known, legal arguments, not new proof. Okay. So as of right now, what they plan on using on January the 7th is already in the defense's hands. So they have what they're going to be using to get her released. The defense attorney already has that. They would lose the case by violating Bradley or Brady, but if they just received it, then yes. They still have to give the defense time to go over it. They may end up throwing out the case if the judge says otherwise. Let me ask something. With what we know so far and the evidence the defense reference, could this case be thrown out? It says it's possible, but it's not the most likely outcome at this stage. The case is far more likely to be reduced, reshaped, or survive on a lesser charge than outright thrown out right now. Thrown out actually means dismissed entirely, which means charges dropped, dismissed without prejudice, can be refiled, reduced charges, defeated later by acquittal, state declines to proceed. Okay, it says it's unlikely but not possible. So unlikely. It says why outright dismissal is a high bar for right now. It says even with no video of the shooting, fragmented witnesses, disputed initiation, and evidence of fear, the court will usually say there are factual disputes for a jury to resolve. Judges don't weigh credibility the way juries do. Oh, okay. So judges don't weigh the credibility the way juries do. They'll leave it up for the jury to say who they believe, basically, is what it's saying. But the most realistic term, pretrial detention can be reversed. Okay, pretrial detention can be reversed. It says the defense does have leverage. Okay, pretrial detention can be reversed. This is the most realistic near-term win. Based on what we know, weak proof of dangerousness, no violent history, no clear intent, viable self-defense theory, release with condition is very much in play. Charges can be reduced. This is more likely than a dismissal. If the state can't eliminate self-defense, can't prove intent clearly, faces credibility problems, they may amend charges, pursue second degree instead of first degree, pursue manslaughter, or offer a plea deal. Now, the case can collapse later. Cases don't always fall apart at the beginning. They often fall apart when the witnesses testifies inconsistently, video contradicts their testimony, impeachment evidence lands, juries can't agree, the state can't meet the burden of proof. That's where acquittal or dismissal mid-trial happens. It says this case would realistically be thrown out if one of these happen. Video emerges clearly showing lawful self-defense. A key state witness is discredited. irreparably. A Brady violation is uncovered. The state concedes it cannot disprove self-defense, or the judge finds that the state failed to meet the statutory burden of it at a critical hearing. None of this has happened yet. All right. All right, let's go over this one more time, and then I'm gonna end it here because I gotta go get me some sleep. What the state must prove to convict Khadijah Johnson. The core burden is always on the state. The state must prove beyond a reasonable doubt that Holly caused Romika's death, and she did so without lawful justification, i.e., not self-defense. If the jury has reasonable doubt on either, the state loses. So to defeat self-defense, which is a big fight for the state, self-defense has been raised. The state must disprove it. That means proving at least one of the following beyond a reasonable doubt: that there was no imminent threat. They must convince the jury that Romika did not pose an imminent danger, or any threat was speculated, not imminent. If juries think that danger might have been imminent, then the doubt remains. Fear was not reasonable. They must show that a reasonable person in Holly's position would not have believed deadly force was necessary. This is the state's strongest path, but it's still a high bar given. A high bar given prior threats, proximity, a child present, and rapid escalation. They must prove that Holly was the aggressor. They must prove Holly initiated the confrontation or escalated it unjustifiably. If the jury isn't convinced who started it, then that creates doubt. They must prove that deadly force was unnecessary or excessive. They must show non-deadly options were clearly available and deadly force went beyond what the situation required. This is where arguments about retreat, number of shots, or timing usually come in. Now, did it say that they need to prove all of it or one? Oh, it says that means proving at least one of the following beyond a reasonable doubt. Oh, okay. They have to prove one of the following. Okay, it says what they must prove for each possible conviction, which right now, first degree, the state must prove intent to kill or cause great bodily harm and no self-defense. Given what we know, this is the hardest for the state. So first degree is basically off the table. I mean, not right now, but you might as well say it is. Second degree, the state must prove Holly intentionally used deadly force, but her belief in the need for second defense was unreasonable, or she acted under intense emotion without lawful justification. This is the state's most realistic target if they win anything. Manslaughter, they must prove reckless conduct causing death without lawful self-defense, still requires eliminating reasonable doubt about justification. Now, what the state cannot do, they cannot win by saying someone died, so it must be murder, relying on emotions alone, ignoring threat history, assuming intent from outcome, filling the gaps with speculation, shifting the burden to the defense. Every gap helps the defense. How does this play with the evidence that we know? Given no video footage of the shooting, fragmented witness accounts, disputed initiation, documented fear context, child present, proximity at the car, the state job is harder than social media makes it sound. They don't just have to tell a story, they have to erase reasonable doubt. All right, I'm about to ask it something. Given what we know right now, with the motion that was filed by the defense. Are there any reasonable doubt as of today? It says, yes, as of today, based on the defense motion and the evidence referenced in the motion, there are identifiable points of reasonable doubt. It says, here's what that means without hype or without overreaching. First, what is reasonable doubt as of today really means? It does not mean the case is over. It does not mean Holly is legally cleared. It does not mean the state cannot win. It means looking at only what's been disclosed and argued thus far. A reasonable jury could have unanswered questions the state has not yet eliminated. Okay? Where reasonable doubt exists today, intent is not clearly proven. No video of the shooting, no confession, no statement of intent, no witness to the trigger pulling. The state must prove intent to kill without lawful justification. At this stage, intent is inferred, not demonstrated. Inference does not equal proof beyond a reasonable doubt. Self-defense has not been eliminated. The defense has raised documented prior threats, a court-issued order of protection with proper nuance, proximity, the proximity of the car door, the body being right at Holly's car door, a rapid close-range confrontation, a child present in the back seat, a disputed initiated of force. The state must disprove self-defense, and as of now, it has not done so conclusively. Witness testimonies is fragmented. No witness saw the entire incident. Only one witness alleged a run-up and swing. Other witnesses were either moving, had limited vantage points, or did not see the shooting. Video undermines at least one witness claim perception. That creates credibility questions, which are classic reasonable doubt territories. Video evidence leave critical gaps. The video shows vehicle moving and positioning. It does not show the shooting, a swing, who initiated force, or a gun being drawn. When the most important moments isn't captured, jurors must rely on interpretations, not certainty. Reasonableness of fear is debatable. Even if jurors ultimately reject self-defense, they must be convinced that the fear was unreasonable, given history, proximity of the body to the car, child being present in the back seat, and inability to clearly retreat mid-task. A reasonable jury could say, I am not sure that I would have felt safe either. This sentence alone equals reasonable doubt. So the most accurate bottom line, yes, reasonable doubt exists at this stage based on lack of direct proof of intent, unresolved self-defense questions, incomplete witness coverage, missing video of the critical moments. That's a legal sound conclusion, not advocacy. So based on the defense motion and what's been disclosed thus far, there are unresolved issues that could support reasonable doubt as of today. Whether that remains later depends on what evidence the state present next. All right. So that's where we at, y'all. How many people sleep? How many people are asleep? She says, wow, can't wait. Wow, can't wait how this drama unfolds. Upset what happened. Holly could have left. Romika should have never stopped. She incited her own death, instigating unnecessary partner should avoid it. Oh, unnecessary pattern should avoid it. Yeah. Yeah, I can't wait till all over too. So how do y'all feel? Let me know. How do people feel? Do y'all still feel the same way you did yesterday? He said, I'm still up. I need to replay this live. Do y'all still feel the same way you did yesterday? And this is for any Ramika supporter too. How do you feel? She said the whole case needs to be thrown away. Are any Ramika supporters still feeling like she's going to get first degree 20 years to life? She said people jumped in like they knew facts, don't even know people or what's all involved. Holly observed everything about Ramika after threatening to be unalive. Claim history, Ramika go after Carlos woman. I think I understand what you're saying. You're saying Holly observed everything about Ramika after threatening to be unalive. Claims history, Ramika go after Carlos woman. She says, I'm up, ho, with your lying ass. Now read this out loud. Ooh, girl, child, you sound hurt, child. Ooh, baby. You sound like you don't like nothing that I just read, girl. Ooh, child, what's wrong with you, honey? Oh my goodness. Oh my goodness, girl. You sound sick, girl. You must have been one of the ones that came on the channel all sick. You got somebody over here in their feelings at this time of the morning. What time is it? Girl, it's 2 o'clock in the morning, almost 3, and you in your feelings, girl. She mad. She like, let me get back over here across the street where they manipulate the dog shit out of me. She said more on Holly's side. Were you on Ramika's side and now you on Holly's side? Did you change up? She said, I don't believe they have a case after hearing the motion, but we'll see. I know, Kathleen, we'll see. Sip and Laugh said, Katie needs some crayons. She sure do, baby. She was deep in her feelings. She said, feeling so deep in their feelings. Yeah, girl. She was deep in her feelings, wasn't she? She like, your lying ass. I don't like this. Let me go back over there where they go manipulate and bullshit me. Let me go back over there and let them tell me that this shit is not gonna fly and she's gonna be locked up forever. They don't like that shit, baby. Oh no. She said, oh my, what's the matter, lady? Oh, she big mad, child. She said, I do have a gut feeling. What's your gut feeling? I do have a gut feeling of most of the stuff you said today. Oh, you said, I do have a gut feeling of most of the stuff you said today. It's crazy. Shaysky said, Ramika supporters are still saying this isn't helping the defense because witnesses identified is out now. LOL. That's where they are at with it. Girl, they didn't want to put them out. Let me tell you, all 4 of the witnesses. Let's go down the list. They don't want to put it out with they dumbasses, but let's put out the 4 witnesses. Okay, we already know Carlos is number 1. He was at the scene. Witness number 2 is a DoorDash driver by the last name of Woods. Witness number 3 is Botello, the damn lying ass Hispanic girl. And witness number 4 is the cross guard that said he ain't seen shit. He just put 2 and 2 together. Lord Jesus. Lord Jesus. I wonder they're going to get some more witnesses. What happened to the 15? Did the state not find them credible or something? I mean, I don't know, y'all. What y'all think? I don't know, y'all. She said, more before I go to sleep. Did you read a knife was on the scene? It explained a lot now. Not one person brought this to light. Yeah, I did see something about a knife being on the scene. But the motion didn't say it. The knife on the scene thing was in the police report. It didn't mention anything in the motion. So I did see something about a knife being on the scene. She said, I looked up the witness on Facebook and the mug shot was posted a year ago. Yep. And they acting like somebody just posted it. Hell, it came off of fucking Facebook. Hey, the mug shot came off of Facebook. They so dumb. They so illiterate. Oh my God, you posted on Facebook. Her mug shot is already on Facebook. Y'all posted her name. All we did was took the name, put it in Facebook, and her mug shot came up. Oh my goodness. You hear me? But the police report, not the police report, I'm sorry. I said the police report. 911 call mentioned a knife, but I don't know where that knife comes in at, y'all. I don't know where that knife comes in at. She said she pissed in her PJs. I see, honey. She over there big mad. Big mad. She said not 1 but 2 mug shots. Okay, Sip and Laugh. Not one, but two. But she needs to be on Tyler Perry movie theater or something, baby, on the damn plays. Cause honey, she came up with a bold face ass lie. Why that girl lie like that, y'all? They star witness is a liar. They star witnesses on camera, baby. You don't care the camera. I guarantee you she didn't think that shit was gonna be on camera. She probably like, wait a minute, what the fuck? This lawyer actually got my ass on camera. Why she go do something like that? Girl, when I tell you, and it's funny because one of the bloggers was like, oh, they trying to run the witness off because they know she the most reliable. Girl, the damn lawyer already is going to destroy her ass. She said, Amor, can you explain how she circled the block again? It's a two-way street, right? Let me just read exactly what it says, okay? Because I don't know if it's a two-way street. So let me just read it. Okay, hold on. I'm going to read exactly what the motion reads. All right, it says, Romika was driving a white Kia. The Kia was traveling eastbound on West Cermak. The Kia then made a U-turn. After making the U-turn, the Kia returned to the area where Holly was located. No, let me do exact words. Hold on. Can you list the exact words? Word from word. I know it say more than that. Hold on, let me just look it up right here. I got it. Let me just read it right here. All right, it says, at approximately 8:51 a.m., a white Kia sedan driving eastbound on Cermak is captured on camera making a U-turn facing westbound on Cermak. And then it says, see exhibit number 2 or whatever. It says the victim owned a white Kia sedan and used to drop her son off at school on 55 West Cermak. Hold on. The son whom she shared in common with Smith. The victim blocked, it says the victim blocked Mrs. Johnson's car by double parking her white Kia on Cermak facing westbound. Now, it actually says in here, but you know, let me tell y'all something. It was somebody that said she wasn't blocked in. See, she wasn't blocked in. She was not blocked in. It says right here, the victim blocked Miss Johnson's car by double parking her white Kia on Cermak facing westbound. Now, Miss Johnson and Smith did not invite the victim over. The victim took it upon herself to approach Miss Johnson and Smith in an unsolicited manner, yelling at them saying, I told y'all I was going to catch you. It says see exhibit 3AXON body. Okay, body camera is the body camera of Carlos giving a statement to the police. Witness 1, Carlos Smith speaking to the officer on the scene. Okay. An argument ensued between Miss Johnson and the victim. Smith noted that Miss Johnson pleaded with the victim. Hold on. Pleaded with the victim. Hold on. Give me a second. All right, it says she I just lost where I was. She said something about she pleaded with the victim. Hold on. Give me a second, y'all. I'm trying to get Carlos' statement that he said she pleaded with the victim. She said, I told y'all I was going to catch y'all. She was waiting. Give me a second. I got to get back to it. When I moved my phone, I lost where I was. Anyway, it said she pleaded with the victim. I got to get back to it. But anyway, what I was supposed to be reading? I was supposed to be reading the, God dang it. Now, in this motion, it actually says the unlawful use of force threatened against Ms. Johnson by the victims were grave and real. Ms. Johnson was genuinely concerned for her safety, given that she was pregnant at the time she was receiving these threats that the victim was going to end her and ultimately her child's life. Mrs. Johnson's concern led to her obtaining an order of protection against the victim in December of 2024. This order of protection was granted in July of 2025, a few months prior to the incident. The victim was served with the order of protection and was aware that this order of protection was placed against her. And it says Exhibit 1, copy of the OP continuing order noting respondent Ms. Blackman was served in open court. A copy of the transcripts for a June 18, 2005 hearing regarding the order of protection was tendered to the court at Ms. Johnson's initial detention hearing. The transcripts entered. So this one right here says she was served, even though Tia and them tried to say that she was not. I don't know what y'all gonna believe. Y'all gonna believe the lawyer, or you gonna believe the reporter? This says the victim blocked her in. I'm trying to get the part where it says she pleaded with Ramika to leave her alone. Please leave me alone. Please leave me alone. She asked Ramika to leave her alone. How many times should you have to ask somebody to leave you alone? Please leave me alone. Please leave me alone. How many times do you have to ask somebody to leave you alone? That probably made her feel like Holly was scared of her. Like, oh, she's scared of me. I'm going to keep on at her ass. She asked the girl to please leave her alone. Anyway. It says the state has failed to prove that Mrs. Johnson committed the offense when improperly relying on uncorroborated witness statements that is not supported by video evidence. When arguing that it has been proven by clear and convincing evidence that the proof is evident and presumption. But anyway, I'm supposed to be talking about the U-turn. I wanted to get the exact words. I'm all over the place. Let's get back to the U-turn. Oh, it says, let me just read this right quick. It says, most importantly, witness number 3 is the state star witness who sees most of it, but ultimately what witness number 3 hears and sees is threats being issued toward the victim by the defendant. Here's victim number 1 telling the victim that the defendant had a gun. Here the defendant making threats to shoot the victim. Yet the statements made by witness number 3 are wholly uncorroborated by the evidence, where witness number 3 was seen walking in the opposite direction of the scene, crossing a busy street 350 feet away from the scene, had her view obstructed and hindered when she was hiding behind a wall under the bridge of the Green Line, and was seen wearing headphones that would make it difficult to capture an argument from 350 feet away. So the girl was hiding, child. The girl was hiding. She was hiding. She said she saw the gun in her hand. She saw her shoot the victim. Ooh, child, girl, you said a whole lot. She was hiding, y'all. She said, let it be known that the headphones are so thick with probable noise cancellation features that the headphones hinder from hearing any outside noise. This is evidenced by witness number 3 removing her headphones and sliding them around her neck when officer attempt to talk to her about the incident once the officers arrived at the scene. And then she got video camera of the witness talking to the officer at the scene. As far as the inconsistencies in her statement and observation, it was approximately 8. Well, I already read that. All right, let's get back to this damn, when she whipped around her Kia. Okay. It says here, well, it don't reference that as a whole. It just references it as small. Okay, this is just talking about witness number 3. All right, hold on. Okay, that's not it. I'm trying to see where it says that she passed and came back. That's what I'm looking for. I'm sure they're going to show these videos in court. I think next court date is going to be very interesting. I think so. All right, hold on. I'm trying to see what she said. She came back around. All right, I owe y'all that one. I'll let y'all know that one. I got to come back to that one. And my eyes are getting heavy. It said that she was going in the opposite direction. It says that witness number 3 was traveling in the opposite direction of the scene and proceeded to do so, missing much more of the event between Johnson and the victim. It says that she alleged she was able to hear Ms. Johnson and the victim yelling at each other while she was on the bus. This is refuted completely where Botella is wearing, okay, the headphones and all that stuff again. Oh, wow. Yeah. Yeah, they got video footage showing that she definitely was didn't see or hear what she said she seen or heard. Damn, not that witness, huh? Hold on. I knew they were gonna get her though. I knew it. I just knew it. I knew they were going to get her, y'all. I did. I'm trying to get the part where they said she made the U-turn, but this is still referencing making the U-turn and then the CTA bus. I want the part where it says she made a U-turn by itself. Mm. Anyway, I owe y'all that tomorrow, y'all. I owe that. But the fist bump is not recorded. I'm just blown away. I just cannot believe this. Oh my God. What happened to all of those people? It was definitely a fist bump. It was. I saw it with my own beady eyes. I saw it. It was definitely a fist bump. It was a fist bump, y'all. I promise you it was. It was a fist bump. Okay. Well, what happened to the fist bump then? What happened to the fist bump, y'all? What happened to the fist bump? Listen, I'm still looking as I'm talking. Okay. I'll do it tomorrow. I'll save that for tomorrow. So I owe y'all that tomorrow. Okay. I owe that for y'all tomorrow. I'm sure it's going to be a whole lot of noise in these streets tomorrow. They're going to try to flip this, turn it in every which way. This is funny. They're going to try to flip it, turn it in every which way, baby. I'm still looking, y'all. It's a lot. Hold on. Anyway, I'm about to go. She said, Amor, do you got the document on your computer as a PDF? No, but I can put it together as a PDF. I don't have it as a PDF as of right now, but I could put it together. You guys want to break it down on your panel? She said, I don't even listen to them, but I might now to see what they say. Strawberry. Oh, $2. Amor, love your girl. Keep doing you. Oh, my goodness. Thank you, baby. I appreciate you, love. Damn. Unexpected love, baby. You hear me? You hear me? Thank you, honey. I appreciate you. She said, let's see what the state rebuttal is going to be like. A bunch of nothing. Girl, hey, I guarantee you it's probably going to be, I don't know. I'm sure that they had to probably put some fluff on this joker. They probably didn't read the whole thing or whatever. Like, nah, but anyway, but it did discount a lot of things that have been put out here. One that, Ramika did not pull up on them. She did, right? She busted Yui and came back to where they were or whatever. That's one thing. She was served in court. There was no fist bump on video. The shooting is not on video. Witness number 3 didn't hear shit she say she heard, didn't see shit she say she saw. She just non-credible all around, child. That's the biggest part of this whole thing for me. That's the biggest part of this whole thing. Witness number 3 is non-credible, baby. All that bullshit you made up, girl, you should be ashamed of yourself, girl. She should be ashamed of herself, girl. But anyway, so far, I don't know. Are y'all impressed with Attorney Ari Williams or no? Are y'all impressed with Attorney Williams or no? Oh, she said I was trying to help you find it faster. No, my eyes is getting heavy. I got to look at it again tomorrow with a fresh set of eyes. When I start getting sleepy like this and my eyes start getting heavy, I really can't see shit. I be struggling. I ain't even gonna lie. She said, I definitely am. Yes. So anyway, now again, I'm pretty sure it's gonna be some people upset. And then it may even say, oh, she just saying that. Well, guess what? When we said the state just saying that, right? We said the state's just saying that. There ain't no evidence what the state's saying. They said it is evidence. It is evidence. It is evidence. But what I like that she did in this motion, she attached her evidence in there. She included video evidence and body cam evidence. She included it in there. So there is evidence that she plans on presenting in court on the 7th. And the reason why I say that is because if she wasn't planning on presenting it, then she would not have listed. So she planned on showing the trial judge some information on the 7th. That's what I'm thinking. So we'll see, you know, if Holly comes home in January. Now, I'm sure they don't want her to come home. Or when it starts getting closer, they might start saying, well, she may come home, but at least she missed Christmas and New Year's Eve. Okay. They may start saying things like that. Okay. But we'll see. We'll see. She said they're going to let Keys help them pick their face up off the floor with them outrageous lies and jokes. She said, I see why the witness has a criminal past. Yes, she does have a criminal past, you know, but she young, so we can't, you know what I'm saying? We can't really, you know, but the only thing I fought her for is all these lies she told to the cops. Boy, she said she cited everything. She did, Jenny. She did. She cited everything. She said, what time is it for you guys? Anyone? Girl, it is 3:12, child. I normally in bed by 3 o'clock. Well, not all the time, but I try to be. So I ain't gonna lie, I am sleepy. She said, I just pray she is released on the 7th. I do believe that she will be released on the 7th. I do. I do believe that she will be released on the 7th. And the reason why I say that is because they was holding her for a fist bump that does not exist, baby. Raise your hand if you claim that you saw that fist bump video. Raise your hand if you say you saw it. Who said they seen it? Be honest. Be honest now. Who said they saw the video? She said Aria's doing her big one. Yeah, this might be a pretty big case for her. Don't nobody want to raise their hand now that said they saw the video. They were like, I saw the video, Amor. I promise you I saw it. Amor, I saw the video. She said this is going to break Romika's family heart, seeing all the dirt she did to Holly. Yep. She said all of Romika's support. All of Romika's supporters saw the video. The video that never exists. She said there was never a video. It was never a damn video. So everybody should know that Q is a goddamn liar. You know what I mean? She said lovely. Her family already know how Romika was. Yeah, you're right about that. They know how her family was. They know how Romika was. So anyway, you guys, just rest easy knowing that a lot of the information that was put out was incorrect. There is no video. There is no video evidence of the shooting, of none of the shit, okay? So right now, we have to just wait and find out what else they have up their sleeves. And I'm sure they probably be like, oh, they just haven't sent the video over to the defense yet. They got it. It's there. It exists, y'all. I promise y'all, it exists. It exists. They just haven't passed it over yet. They just haven't passed the video over yet. Okay. All right. Well, She'll be home for what's in January, y'all? President's Day. No, that ain't President's Day. What's in January? I think it is President's Day. But I do believe that she will be coming home. She said, Amore, I'm so happy I waited and wasn't one of the ones that got upset with you. Thank God. Hey, listen, it's a lot of people did get upset, but I kept saying this is not about emotions and morals, right? They kept saying, well, morally she was wrong. But I said, let's stick with law. Let's stick with law. But I'm glad you didn't get upset with me either, Kimberly. I'm glad you didn't get upset with me. So we're going to ride this out together, okay? We're going to see this case play out together, okay? Ain't no need for nobody to get mad at nobody, baby. Nobody, all right? Oh, for Carson's birthday. Oh, okay, so she'll be home for Carson's birthday. MLK Day is January 19th. Okay, Martin Luther King. Okay, so she'll be home for MLK. She'll be home for MLK Day. So, I mean, you know, we'll just have to see. Good night, Michelle. We'll just have to see, but I do believe that she's going to be coming home. She said Tia Irwin's going to report this. Hell no. No, I don't think that she's going to report this. Or she might report it and be like, the defense attorney is just not being honest right now. Well, girl, no, go read that transcript. Let's see if she gonna report what happens in court on January 7th. She said, host, you did best given the facts. I was team Ramika, but felt there was more to the story. At best review, Ramika instigated the situation. Holly reacted badly. I see first degree bump to manslaughter. Well, you know what? You know what I'm gonna say to you? At least you see that it's not first degree. If you know, because I'm definitely not trying to win nobody's mind over, right? But I just spoke the law, and a lot of people didn't like that I was reading the law. I was literally reading the law. But I'm glad that you see that it is not first degree. Because Holly did not instigate this. Now, she probably reacted badly. She probably was scared or whatever, you know. But like I said yesterday, she reacted like a lot of people would react, and I'm one of those people. Not saying that it may be a good choice, but I would act the same way Holly did, okay? So, but at least you see now that it is not first degree. It is absolutely not first degree. So those people like, oh, she going down for first degree. They wouldn't charge first degree if it wasn't first degree. Well, they charge first degree and they don't have no evidence except for the witness statements. Like, let's be real. A witness statement, no video footage, and then not even two witness statements that say the same things. No collaborating witness statements. Two people are not saying, oh yeah, we saw this together. No, all four of the statements say something totally different. It's inconsistencies. Inconsistencies. And then you got to understand, if Holly takes the stand, then that's her statement. And her statement is going to collaborate with Carlos' statement. I don't know how that's going to work though, but I'm just happy to see that at least one Ramika supporter realized that this is not a first degree murder charge. David told us that they overcharged. This was an overcharge, especially with the lack of evidence that they have. Come on, state attorney. Did you really do this? She said, I really want to know why they charge her, like really seriously, especially with what they have, right? With what we see. This is weak. This is very weak. So I see a lower charge or self-defense, but I'm going to go out on the limb and say, I see a self-defense verdict. I really do. That's my honest opinion. I see a self-defense verdict. I see a self-defense justifiable homicide verdict. I do. I really, really do. And you know, I'm just going to say this. I'm just going to put this out. It's a couple of content creators that was actually, you know, seeing it the legal way and saying justice for, not what they weren't saying justice for nobody, but they saw it the legal way. And then when she got locked up, they changed their view because they automatically believed everything that was read by that reporter. They believed that without even hearing the other side. And I'm actually a little like shocked about that, but they really believed the reporter. One-sided information. They believed that there was evidence of a fist bump. They believed that it was video footage of her antagonizing Romika. They believed that. Oh, well, if she fist bumped, but where's the evidence of the fist bump? Well, they say it was on camera. Well, then where is it at then? Where is it at? So anyway, so is there a way to see all 4 witness statements to see the inconsistencies? Yeah. Well, the whole statement. So in this motion, it doesn't state the whole statement. It only gives an overview. So these are not the whole statements, but let me just ask for the inconsistencies. Hold on. Well, the inconsistencies are none of them see the same thing. Their stories are quite different. Let's go over it again really quickly. Just the statements. Well, you know, already Carlos said that she ran up, she got the car saying, I told y'all I was going to see y'all together, right? All right, this is what it says. It says, witness number 1. Oh, hold on. Let me go back to it. God dang it, more. Why I start at number 2? Why I start at number 2? Maybe because we already went on witness number 1. Okay, so witness number 1, you know, was Carlos. He basically said that she got out of the car saying, I told y'all I was going to catch y'all together. Argument started and he tried to break up, you know, standing between them, arguing or whatever. And she ran towards Holly and made physical contact with Holly's face. Okay. Witness number 2 said he was driving eastbound on Cermak to pick up a DoorDash order. And while he was driving, he briefly saw the 2 females arguing and Carlos standing in between them. That's about it. He said he didn't see shit else. No weapon, no gun, no shooting. And then he heard the shots from inside a coffee shop. Witness number 3, that's the one that had all the outlandish lies, okay? She claimed that she heard threats. Someone say she's gonna go get her gun. Heard all these 5 shots. She was on the CTA bus and all that stuff. Anyway, y'all know witness number 3 was just a whole lie. And then witness number 4 literally says that he did not see Miss Johnson. No, all of them said that they did not. So the things that all of them said, except for Carlos, is that they did not see Holly shoot the gun. They did not actually, yeah, they did not see her shoot the weapon. So, but he said that the only way he knew that she was the shooter, this is witness number 4, the cross guard guy. The only way he knew she was a shooter is because he heard her say, I have a concealed and carry. And then he said he put 2 and 2 together and made an assumption that she was the shooter. So none of the witnesses basically say the same thing except for they did not see the shooting. Now, witness number 3 says she saw everything under the sun. But Ari basically disputed hers the most, showed where she did not see what she say she saw. She did not hear what she say she heard. Like, she disputed hers the most. She came after her hard. She tracked her location. She saw her on the bus, saw her getting off the bus, saw her walking in the opposite of the bus. She saw everything this girl did that day. So she already then ripped witness number 3 apart already. So neither one of them, no one saw the shooting. No one was there for that. They did not see that. They must have been new to being a web sleuth because you have to dig for yourself to get the truth. Yeah, that's true. You do have to dig for yourself to get the truth. You can't just believe what comes out on the internet. You really can't. And that's the honest God truth. Because guess what? if you do just believe what comes out on the internet, we'll be wrong so many times. When this story first came out and we heard that Carlos held her in a chokehold and Holly shot her, I believed that myself. I was like, damn, what type of cruel ass baby mama is that? And then when they said they let her go, I was like, wait a minute, why did her go if she executed this girl? That don't make no sense to me. And I said, oh nah, this shit can't be true. And then I thought about it and I was like, wait a minute. If she would have shot this woman while being held in a headlock, then he would have some type of wound, some type of injury. It just didn't make sense to me. It absolutely didn't make sense. She said, do you think that witness number 3 will change now that she knows that she's on camera? Well, let me just say it like this. Do I think she will change? I don't think that even if she changed right now, like change and tell the truth, do I think she'll come out and say, oh no, I really didn't see it? No, I don't think she'll do that. No, I don't think she'll do that. However, even if she do try to change anything that she says, everything that she says is going to be used against her. First statement, second statement, third statement, it's all going to be used against her. She says, so they did not see Holly approach Ramika like the others are reporting. That's crazy. Nope. They did not see that. Absolutely did not see that. Absolutely did not. And I heard one blogger say this about attorney Ari. So you're calling the witness a liar? Video footage proves that she's a liar. Video footage proves that witness number 3 is a liar. So no. Attorney Ari is not calling her a liar. Video footage proves that she is a liar. Video footage tracked her every move. Now, do I think that she knew that that would happen? No, I don't think that she knew that she was going to be tracked. I don't think that she knew Ari was going to pull the inside of the camera footage. I don't think she knew Ari was going to pull getting off the bus footage, walking the opposite way footage. I don't think she knew Ari was going to track her moves. And I don't think that the bloggers knew that either. I don't think they thought about that. But you have to understand, a good attorney, a good one, of course they're going to come after the damn star witness. You think they're not? But I had already said, and I'm going to pat myself on the back, I said, a good defense attorney is going to eat her ass up. I'm not even an attorney. And I was finding inconsistencies in her story. I said, wait a minute. How she on the bus and heard this? And then the bus went through a light underneath a bridge, dropped her off. She had to cross the street, come back. And then she said she was over by the smoothie shop. I said, wait a minute. She saw and heard every damn thing, and she was all en route. I said, it doesn't make any sense. And I'm not even an attorney nor an investigator. But I ain't dumb. I ain't stupid. So I knew Ari was going to eat her alive. And she did. And she's going to. Michelle said she didn't know she was being recorded on all those cameras, I believe. No, she didn't know. She didn't know. She was in too many places. Sure was. And had on headphones. Come on, over-the-ear headphones. It's sitting on the bus. But you heard everything? Girl, bye. She's at the smoothie shop, sits at the corner, and according to the video evidence, she was not at the smoothie shop. I heard that she was in the back of the smoothie shop. That's what the motion says. She was in the back of the building. She was in the back of the building, hiding. She was hiding. Girl, you was doing too much. Too much. I looked into her eyes when she fell to the ground. I looked into her eyes. That girl is a damn theatrical liar. She committed a clear act of perjury intentionally. She's going to jail the whole time. She thought the camera was facing the street and it was facing her. I actually don't think that she can go to jail. And the reason why I say that is because if she told the lie under oath, she can go to jail. But I don't know if making a statement to the police is offensible. You know what I mean? I don't think they read you your rights or anything when you're making a statement. But then again, I don't know. But I don't think that she'll get in any trouble. She'll just be looked at as non-credible and they won't use her statement, right? But I don't think that she would go to jail. She said, yes, there's interest to the train station on that alley right there. Yeah. And then listen, to find out the bus didn't stop, because I actually gave the bus. I was like, maybe it stopped at the light and this, and the other. The bus didn't even stop, y'all. It didn't even stop at the light. She said, did they say that the bus caught the fist bump? Was that true? No, ma'am. The fist bump video does not exist. Let me say that again. The fist bump video does not exist. It says the state attorney relied on witness number 3. Her statement about the fist bump. And then the attorney even said that the fist bump wasn't even mentioned originally. It came later. That came out later. It didn't even come initially. No, you're welcome. You're welcome. You are welcome. So the fist bump video does not exist. The state relied heavily on the witness statement. She said, you definitely called it. The Ramika supporters went with the headlock only. They didn't go with, she said, Ramika slipped away and confirming there was a fight. Oh, they definitely did not want to. I heard somebody say today, it said physical contact was made. Does that mean physical contact, meaning did she actually hit her or did she like just touch her? Like they move the goalpost and be stretching it like a piece of bubble gum, like Laffy Taffy or some shit, right? Yes, she is the star witness. Shasky said, if the glove don't fit, you must have quit. Okay. Okay. So, but nevertheless, I mean, the state has an uphill battle. However, this is not over yet, you guys. It's not over. We ain't claiming no victory, but we are claiming victory for discrediting some things and finding out some things that we were not sure about. And now that we know for facts that there is no fist bump video, for facts, we know that she did a U-turn and came back to where they were. That's on video. That's on video. That is on video. Okay. So anyway, I mean, but like I said, in my opinion, I just want a fair trial for Holly, fair case for Holly, because she deserves that. Even though people was condemning her already to prison for life, they were condemning her, baby. Condemning her. Oh, she's a murderer. Self-defense is not murder. I hope you guys know that too. Self-defense does not equal murder. It does not equal murder. So anyway, I had to come live because I couldn't believe it. I was like, wait a minute, no fist bump. Wait a minute, no photo or video of the shooting, but you got a video of her on the bus with headphones on, looking for 9 seconds, and was out. She was absent, y'all, for 9 minutes of the entire incident. For 9 minutes, she was nowhere around. For 9 whole minutes. Make that make sense. Make it make sense. She said they were sentencing her without a guilty verdict. They sure was. They sure was. They was sentencing her and throwing away the damn key. So anyway. So I'm about to go. Kathleen says she is the star witness. She signed a sworn statement. This can throw the whole case, not saying it will, but the judge and the state relied on her being truthful. Yes, they did. She said, I guess the YouTube gonna be hot today. Girl, they gonna listen. Somebody sent me some. They already got my pictures up, honey. They already over there. Now let me show y'all some. This how you know right here when you saying something that people don't want to hear, right? Look at this. They already over there. I'm assuming this is the is this the same person? I don't know if this is the same person or not. I guess it's the same person. But look, and since she put my picture up, I'm gonna put hers up, okay? Yeah, that's what we're gonna do. Since she put my pictures up, I'm gonna put hers up. But this person already so mad over there mad about me. She put my pictures up on her page. Look at this. That's my picture. They mad. Look at them. They big mad. They big mad. Why you? Huh? What you mean for? That ain't the only one. Hold on. She put that one up. That's me. Shit, I can't deny me, baby. That's me, honey. And then she put me and my husband up. She over there talking about me and my honey. Girl. She over there talking about me and my honey. Oh, hold on. Where is this one at? Oh, hold on. Let me open it up. She over there talking about me and my honey. She must be in her feelings. She over there posting me and my honey. She mad. Oh, she mad. She is mad. That's me and my honey. That's my love. She over there real mad, y'all. But since she gonna put my picture up, let's put hers up right quick. You know, ain't no shame in my game. It is what it is. I is who I say I is, right? I is who I say I is. But let's put her picture up right quick. Since she wants to put mine up, honey, let's share it. Shall we? Hold on. Let me get it. Shall we? Shall we? All right, let's put hers up. So I guess this is the politician girl. She's upset, right? So she put my picture up. So this is her picture. This is her profile picture, right? That's how her profile look. You see that? But then she went live. That's how she looked. You see that? Does that right there look like that person? See, that's her live. She went live, y'all. That's how she looked live. But this how she look on her photo. She look a little different, don't she? That's how photo look, and then that's her. Yeah, this is her. Uh-huh. Oh, Miss Politician. Or tricking or whatever. That's her. They be over there talking about, you lying bitches. You this, you that. That's her. This is her. Mm-hmm. Yeah. She went live. Mm-hmm. While she over there showing my photos. Okay, girl, do your thing. Do your thing. Do your thing, girl. Do your thing, baby. Anyway, while she over there wanting to show my pictures, it sounds like she's a little upset, honey. She's a little upset. She over there showing me and my husband. Show your husband, girl. Show your husband, girl. Show your husband. Anyway, but that's politician tricking or whatever you want to call it. She said, don't let her strike your page because that's what she put you on Facebook. I'm just saying. She ain't gonna strike my page. I'm too smart for these clowns. She said, how y'all mad at Amora that the witness lied? Exactly, Kathleen. What they mad at me for? See, they were perfectly okay only hearing one side of the story, and they was running with it. They was running for their life. They were running with it. They were running. No, we just gonna ignore the witness. We just gonna ignore the witness. No, we're not gonna ignore the witness. But they failed to dissect the witness statement. They failed to analyze the witness statement. They ain't even try to crosswalk it. They didn't even try to say, is this witness really reliable? Is she? They didn't care if she was reliable or not. The witness was saying what they wanted to hear. So they ran with it. They ran with it. But nevertheless, again, we still gonna wait until more information come out. But y'all know I'm gonna stay on top of the story. I'm gonna read the facts. And right now, the witness statements, all three of them, are inconsistent of one another. There is no evidence except for that witness number 3 is a liar, and that Romika did a U-turn and pulled up to Holly and Carlos. But other than that, there is no evidence of nothing else. There is no evidence of nothing else. So anyway, thank y'all for pulling up. Thank you, Barbara Clark, for showing this love. I appreciate you, baby. Thank you, I am and my sister teacher, for becoming a member. Thank you, Candy Girl, always and forever. Sassy D, she said, well, damn, call the ambulance because I'm done. She must have said that on the part when there was no fist, when you found out there was no fist bump video. Thank you, Tisha. Amor, do you think it's going to trial after this? I think it's still going to go to trial. I do. I think it's still going to go to trial. I really do. Thank you, S Gums. Appreciate you. And truth be told, she said, I so much love it here. I will catch replay. I love you. Keep up the good work. You are made for this. Thank you so much. I appreciate you so much. I appreciate you. And then thank you, Barbara. She says, Amor, love your growth. Keep doing you. Thank you. I appreciate you guys. She says she should drive away from trouble. She was blocked in per the defense motion. It says that Romika blocked Holly in. That's what it says on the paperwork. Romika blocked Holly in. Holly was blocked in. So those people that came out here and told me she was not blocked in. Well, the attorney said she was. I'm sure the attorney hired some person to go out there and look, some professionals. She ain't just pulling shit out her ass. I'm sure she invested some money and went out there to find out for herself, or got some professional to do something. I'm sure she did. That's what they do. They use some of the money and they have other people go out there and find out like proximities and shit like that. That's what they do. That's what they do. So, but she couldn't have drove off because Romika had Holly blocked in. She was blocked in. That's what the motion says, baby. She was blocked in, okay? She said, but how you gonna say the judge didn't see evidence of a fist bump? Why he say that then? Why he say it then? Why he say what? Lovely day. He didn't say he saw it. I kept telling y'all, the judge did not receive any evidence. The state attorney told him that there was a fist bump, and he relied on the state attorney. There was no evidence exchange. The state attorney know that he didn't have no evidence of no fist bump. He said he or she, I think it's a she, state attorney. They got that from, they got that information from witness number 3. But this is what I would do for any of the Romika supporters, because I know y'all go and watch other Romika content creators. I would like for you to just challenge the content creator, your favorite, and ask them tomorrow, where is the video that y'all said was of the fist bump? Where is that video? Where is the evidence that the judge saw? Ask them that. Challenge them. Push back on them and say, where is the evidence of the fist bump? Where is the evidence to discount what Attorney Ari is saying about witness number 3? Tell them to explain why witness number 3 was not on the scene during the incident or the shooting. Tell them to explain how witness number 3 said or alleged that she saw what she saw. Push back on them. They're going to cuss you out probably. They're going to get mad. They're going to get furious. But yeah, ask them. Ask them, where is the evidence that you guys said that's going to put her down for 20 years? Where is it? Where is it? Because right now, I smell reasonable doubt. Right now, I smell reasonable doubt, okay? And reasonable doubt, well, that doesn't win cases. That doesn't win cases. But anyway, y'all, I appreciate y'all so very much for pulling up. I know it's late. I definitely didn't mean to be 4 hours, but it is what it is. I love y'all. I appreciate y'all. And I will talk to y'all tomorrow, okay? All right, good night, everyone.
Because they can't make $1 without mentioning down one of our names.
Jay! She kept talking about that family.
Hoes over there.
She kept talking about that family. 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 That family. She kept talking about that family. Talking about that family.
These motherfuckers don't be wanting to listen on them. Because they can't make $1 without mentioning down one of our names. Talking about it, talking about it, talking about it. That family. That family. That family. That family. Jay! That family. That family. Talking about it, talking about it, talking about it. Dollar. Talking about it, talking about it, talking about it.
Child, we finna talk about this with Amora.